Being 6 o'clock, we'll call the meeting to the Board of Adjustment and Appeals to order. First order of business is roll call. You gonna do that or shall I? Ken Anderson?
Here.
Larry Hefner is present. Dana Chomey?
Here.
Brian Van Gorp?
Here.
Ken Visger?
Here.
Are there any additions or corrections to the agenda? Not, we'll entertain a motion to approve the agenda as presented.
I make a motion to approve the agenda.
We've had a motion and a second, Ken? Second to approve the agenda, all in favor say aye.
Aye.
All opposed, same. We're gonna do the minutes now? Sure.
Sure.
Okay. Are there any corrections to the minutes? If there are no corrections, I'll entertain a motion to approve the minutes.
So move. I'll second it.
We have a motion and second to approve the minutes. All in favor say aye.
Aye.
All opposed, same sign. The next order of business is to read the guidelines for public testimony. I think we're a small enough group tonight, but do you want to bring that up?
Well, it's up to you.
Sure, go ahead.
The audience is asked to refrain from crosstalk and commentary. If you'd like to provide a comment, I guess please indicate so when asked by the board. All comments must be directed to the board. Commenters are asked to limit the scope of comments to the issues being addressed tonight. If the comment you wish to make has already been put forth by others, there's no need to repeat it. Instead, simply say that you support the comment made by so-and-so. And at the discretion of the chair, comments may be limited in time to no more than, I guess that would be a decision to make tonight based on that small audience. Are you?
We're pretty lenient with it.
Okay, so we'll put no time limit on that then. Only one person will address the board at a time. Individuals cannot defer or give time to others. At all times, individuals will refrain from name-calling, slander, vulgar language, derogatory marks, finger-pointing, or other inappropriate language or gestures. If the need arises, the zoning administrator will serve as the official timekeeper. And in the event that the audience members fail to act according to these standards, warnings and ultimately removal may take place. However, the expectation is that these guidelines will be self-enforced.
Thank you. This hearing is for Crocaw Companies, Winnebago Township. They're appealing the zoning administrator's decision of February 8th, 2018. At this point, I'll entertain a motion to recess the Board of Adjustment meeting and open public hearing to consider the applicant's information.
So move. I'll second it.
We have a motion and a second to recess the Board of Adjustment meeting and open public hearing. All in favor say aye.
Aye.
Opposed, same sign. Do any members wish to recuse themselves at this time for a conflict of interest concerning this request? Hearing none, we will move on.
Well, I would say that the applicant has requested the opportunity to speak at this point.
Oh, yeah. Yeah, okay. Are you the applicant?
Yes, for recusals.
Oh, I see it concerning recusal. I'm sorry.
You want to move over by the mic?
I tend to speak loud when I.
Okay. Thank you, Mike.
I don't think those mics are working. They weren't.
They're on. You got
I
to
can
get
hear
in
it
there,
better
and
now.
much of it might go
I can hear Mike.
for the purpose of the recording. So even if we can hear you here, we want to get it.
Yeah, get in it and
Recording.
closer, would you please? Like you said, we want to be able, if we have to go back to the recording, we want to be able to hear it. Thank
Yes.
you.
So questions of impartiality of board members are necessary for the legitimacy of the process. For that reason, I need to raise the issue of recusals. First, Mr. Van Gorp. Mr. Van Gorp, in your 2018 application for your appointment to the Board of Adjustment, you state a conflict with regard to the Erickson mine that would require your recusal. As the leaseholder and operator of the Erickson mine, your involvement in our appeal creates a conflict and a potential for prejudgment and bias. Given the contentious nature surrounding that site, the numerous complaints you have filed against us, and the lawsuits that resulted from those complaints. Furthermore, you are tied to the Houston County Protectors, and so are the complainants that originally filed the complaint that led to this appeal. You even raised concerns with their attempt to appeal their complaints to the Board of Adjustment at the county board meeting on November 7, 2017. You are also the subject of a May 3, 2017 cease and desist order from us for false statements you made at a board meeting. You proceeded to call us at that following board meeting bullies on May 16, 2017. You have also engaged in ex parte communications with board members in quasi-judicial proceedings involving us and did not disclose those contacts. In fact, you denied them on the record. For example, on the Erickson pit last year, you disputed claims that you and the other petitioners met privately with commissioners. But in an email that was produced in a subsequent data request, it shows your wife and Mrs. Baker met with Commissioner Arnold before a hearing and gave him documents that were never produced to us as the other party in that appeal. You have also made the following public statements regarding non-conforming mines, and these were all public. You will have no control unless you bring non-conforming uses into the permitting process. Non-conforming mines are rogue activity. Non-conforming mines must end. The burden of maintaining non-conforming use is on the landowner, which is incorrect. These demonstrate a clear position against non-conforming uses, which is at the issue on this appeal tonight. Even though they are protected by state law, these statements show clear bias and prejudgment on our appeal. Your involvement in this appeal would likely render any decision arbitrary, and you must therefore recuse yourself. And I have all documents to support everything that I just stated.
What was the thing about the cease and desist order? I don't know what you're talking about there.
On May 3rd, 2017, cease and desist order to you and the other plaintiffs for making false statements. You then proceeded at the following board meeting to call us bullies because you didn't believe in that cease and desist order was legitimate.
I never received a cease and desist order.
Your attorney did, and you referenced it at the board meeting, Mr. Van Gorp.
I never received such an order. But I may have called you a bully, I don't remember that, but you were behaving like a bully at the time. I will address each of those things, and if I miss any, please refresh my memory. Regarding the Erickson mine, our position against that mine was valid based on a district court decision. And this was about a frac sand mine at the time. This mine that's under discussion tonight is a gravel pit. I don't even know where this pit is. I couldn't drive to it. I have no prior interest in this gravel pit. I don't know who the owner of the land is. I wouldn't recognize it if I saw him on the street. And I do not know Gary Krukow. I would not recognize him if I saw him on the street. I know you because you testified in the Erickson case. But other than that, I know nothing about any of the parties in this case, and I have no prejudice against any of the
Would
parties
you
in
like
this
me to
case.
read your statement where you called us bullies referencing the cease and desist order?
If you'd like, I don't care.
This is what you submitted to the county board on May 16, 2017. From you, Mr. Van Gorp. The bullying continues. We recently received a letter from the Ericksons and Krukow attorney, Ms. Lear, accusing us of defamation and demanding an apology on the county board. Do you still not remember this?
Is there anything untrue about that?
No, but you just denied knowing about it and receiving it.
No, I didn't. I said I don't know Gary Krukow and I don't know Gary Miners.
I'm talking about the cease and desist order, Mr. Van Gorp.
I don't remember that. No, I don't
You
remember
just
getting
denied
such
it,
an
but
order.
I just showed you, you referenced it.
I did not receive in paper saying there was a cease and desist order.
Hold
You
on,
mentioned you
I
received it.
don't think we need to get into all that detail. From my understanding of procedure, unless you think we should go into this more.
Well, I think
I would
maybe
like to address these other issues.
before we get really far into the weeds here, we should set some parameters. There's a procedure when there's a question or an allegation of a conflict of interest that the unaccused members need to make a determination on the individual against who the accusation is leveled. Conflict of interest. So the state law reads that any question on whether a particular issue involves a conflict of interest sufficient to disqualify a regular board member from voting thereon shall be decided by a majority vote of all regular board members except the member who is being challenged. Conflict of interest is defined in the Houston County Code of Ethics. The following actions by an employee or public official of the County of Houston shall be deemed a conflict of interest. First, use or attempted use of their official position to secure benefits, privileges, exemptions, or advantages for themselves or their immediate family, or an organization with which they are associated, which are different from those available to the general public. Second, acceptance of other employment or contractual relationship that will affect their independent judgment in the exercise of their official duties. Third, act as an agent or attorney in any action or matter pending before the County of Houston, except in the proper discharge of official duties or on their own behalf. And finally, the solicitation of a financial agreement for themselves or entity other than the county when the county is currently engaged in the provision of the services which are the subject of the agreement, or where the county has expressed an intention to engage in competition for the provisions of the services, unless the affected county agency waives this clause. So in hearing the evidence provided or the allegations provided by the applicant, that is the framework through which you're looking at the information being provided, I suppose.
Clearly, I have not done any of those.
So what's the next step?
Well,
Do we want to finish this conversation, get this fleshed out first?
perhaps.
And then the rest of the members vote on whether or not,
Based on the things that Aaron just read, I have not done any of those things. And I am not against mining. I have stated publicly at several meetings, including commissioner meetings, that I am not against mining and that we need mines in this county. I myself live on a gravel road with a gravel driveway and have a septic tank. So,
Mr. Van Gorp, and with all due respect, we're not here just talking about mining. We're talking about a non-conforming use.
Yes, I understand
You made
that.
public statements. Due process. Now, due process requires that you have an impartial decision maker. Okay, that's beyond what just Mr. Locker read. Due process requires an impartial, unbiased decision maker. And based on what I already stated, you have made clear public statements to the contrary that you are against non-conforming mines. That shows prejudgment and bias.
I think you're incorrect there. I've said that there are some mines in this county that have non-conforming status that shouldn't have
I
it.
can show you your statements.
I am not against non-conforming uses, and I've never said that I was against all non-conforming uses. I am against non-conforming uses that are operating illegally.
Do you have any more information?
Again, I think I laid out sufficient grounds that Mr. Van Gorp's included in not recusing himself is against due process, and he has a clear conflict bias. He even referred to me as a bully just at the beginning. So I think that he would be unable to be impartial in this decision.
do any of the other board members have any, need to look for any more information, have any questions? Like further explanations on this? Hearing none, the other members will vote whether he should be, Ryan should be excused from this hearing. Ken?
Before you
Yeah.
vote, I think we'd like a motion, and I think I'd like to have it specify whether it's not voting, not participating at all, specifically.
Okay.
So maybe entertain a motion, one way or the other from anyone that specifies, precisely what, whoever's making the motion would prefer.
I guess our options are participate in the questioning, but not voting, or completely excused. There were the two
I think
options.
those are the two options.
Anybody have a motion? Or
Wait, go back. Participate but not voting? Or fully
Participate in the
participate?
discussion, but not vote.
Isn't there a fully participating
Yeah,
option?
well, of course, I mean, that.
Oh,
that
yes,
gives
I'm
three-
sorry. Okay.
If you're
Okay,
looking for.
I'm
a-
sorry, sure. You have three options. Okay.
I have a question. Are you done, do you have any other people you want to get off the decision?
I
So
think
we
we
don't
should
have
address-
somebody,
I-
so we don't have anybody voting that you might want to get off. Are you done?
No.
That's okay.
Will you have more information on this?
So how,
Yes.
Oh, I'm
so
sorry.
you would have some, if he wants more people off, you might have somebody voting that he wants off.
Oh, yeah.
You know what I'm saying?
Yep, sorry about that.
I'll follow you, Dean.
Or do we, well,
Okay.
let's go with that.
Mr. Hafner, in your 2018 application for reappointment to the Planning Commission, from which you are appointed as a representative to the Board of Adjustment, when asked to list up to 3 significant issues that you believe this board should address in the next 3 years, you list just one: register and get CUPs for all quarries. This is a clear position against non-conforming uses, which are protected property rights by law. This statement shows clear bias on our appeal and the potential for prejudgment, as the outcome of this appeal determines whether we would need to get a CUP for this site. Not only that, but on February 20th, 2018, you then advised another mining company to stay with legal nonconforming status because the general public is overly sensitive to anything to do with mining at this point. Now, I respect you, Mr. Hafner, and I personally think you are a very reasonable person. But these statements demonstrate clear bias and also require you to recuse yourself.
Okay. I guess I'll leave that up to the rest of the commissioners. I can certainly understand what you're saying. I'm surprised at it. I mean, I'm not disagreeing with you, though. I think the goal for having all mines be registered eventually is I still agree with it. I don't have any need to have them, as long as everything is as it should be. I don't have any desire to, force anybody into it, but I think the long-term goal is to have them all
And
registered.
again, this is nothing personal. It's
Yeah, I
to make
understand.
sure that the process is
Yeah.
legitimate. When these conflicts and biases exist, those board members need to remain neutral. And if there's instances or public statements that counter that, there's the appearance of impartiality, and it taints the process.
I agree, I understand.
I would add at that point that the non-conforming uses are addressed in the ordinance, and Michael's right, that if you meet that criteria, it is a property right. However, even in the ordinance, it says that they're not to be encouraged.
Oh, no.
So it
It's a
wouldn't be.
misunderstanding on my part.
It wouldn't be.
Yeah, I can understand. I'm trying, I don't know, I guess I left up to.
I guess my point is that it's not necessary to be a cheerleader for them when our official county policy is to
Yep,
discourage
yep,
them.
Yep, I understand.
Yeah.
Yeah, that was an error on my part. Maybe I'll just recuse myself then, huh?
I mean, that's a decision you need to make.
I will leave it to the rest of the board and the members that can vote on that as well.
All right, Michael, continue.
Any more?
I have no more.
Okay.
We're not a people.
No.
And I apologize for that.
I
That
understand.
was poorly. Do we handle these one at a time?
I think one at a time.
Okay. Well, let's go with the first one first. Apparently, Brian and I cannot vote on either one of these.
I think maybe
Maybe we should ask them.
county attorney, is that correct? You're correct, yep.
I would, if we're dealing with Mr. Hafner, and Mr.
Oh, is that right? Okay.
Okay, is that what you're saying?
Okay, I will entertain a motion for Brian Van Gorp's continued participation in this meeting.
I would move that Brian Van Gorp be allowed to participate fully.
You have a reason why?
I guess I didn't hear the things that were talked about. To me, did not indicate an unwillingness to look at this unbiasedly, or without bias.
Do I have a second to that? Do I have a second to that? Do I have a second to that? Not hearing a second, the motion is what? Defeated? Whether I have to entertain a motion? Another motion.
Yes, I would move that Brian can participate in the discussion but not vote.
Ken, do you have a reason for?
I believe that his conflict of interest and the prior statements and stuff with mining in general.
Do I have a second to that?
I'll second that, and the reason I do that is because I believe Ryan is a fair person, but I just don't, his inclusion on this might make a perception of impartiality, and that's the only reason I do that, Ryan.
We have a motion and seconded to allow Brian to continue as part of the discussion, but not to vote on the final outcome. Wait a minute.
Aye.
Aye.
Do I need to restate that? Can he vote on the findings,
I think the
Probably
motion was to
not.
allow him to participate in
but not
the
vote, period?
discussion, but not vote.
Yep.
Is that correct?
Yep. Eric?
Yep.
Okay, good. Okay, all in favor say aye.
Aye.
All opposed?
Aye.
We
So,
had-
Larry, where are you on that?
You're voting to.
Yeah,
Hmm,
you're voting too.
yeah, that's right. All opposed?
Opposed. So, that
Huh.
Now what?
puts us in a
You have to have a majority to pass.
to pass. Okay. So the motion fails.
Yep.
What do we do then?
Well, I think you just
Motion failed.
There is no motion
Yeah.
one way, we have no motion one way or two.
Yeah, yeah.
To address. You can entertain another motion.
I'll entertain another motion. We've had. What else do we have left is a motion to,
What do you do?
To remove. That's the only
remove.
one we
yeah. Motion to remove from the proceedings. I'll make a motion to remove from the proceedings. Is there a second? Is there a second to the motion?
I'll second it so it's brought up for a vote.
Okay. We have a motion and seconded to completely remove Brian from the proceedings. All in favor say aye.
Aye.
All opposed, no. Or same sign.
Aye.
The motion fails.
What is the default here?
Mr. Van Gorp did not remove himself, so the board went through its process here, they all failed.
Same process, but in this case, Ken, you would take the reins as vice chair to
I didn't know that.
handle Larry, I believe.
Thanks for the appointment. So I guess we're open to motions regarding Larry Hafner. And again, here's it's either to remove, allow to participate without voting, or to participate fully.
I'll make a motion that Mr. Hafner be allowed to participate fully.
Is there a second? Is there a second? Failing a second, the motion fails. Any other motions? Any other motions?
I'll make the motion to allow him to participate but not vote.
Second?
I'll second that.
There's a motion and a second to allow Larry Hafner to participate in discussions but not have voting privileges. Any discussion?
Ken, reason for your
Basically the
motion?
same reason I did for
Oh, I'm sorry.
Brian.
Any discussion? There being no discussion, all in favor say aye.
Aye.
Opposed?
Opposed.
Aye.
You're voting opposed?
I'm voting opposed.
Okay. So is it correct that we are reverting to a default position for fail of anything to pass?
Yep.
Okay.
Ed, I'd like to submit these documents that support the statements for the record, so that way if the district court needs to review this.
Certainly, if you want to provide those to Holly, we'll make sure they are in the record.
Do we take comments at this point?
Somebody raise their hand.
I don't think so. We are at
Staff reports.
staff report.
Be next.
She's ahead of her.
Give me 1 second here to catch up.
Go ahead. What do you have that you think is
I just
important?
want to remind you that when the planning and zoning board met about the Winnebago quarry, Ed Hummel had recused himself, and yet he voted for everything that night. So I hope this isn't a precedent for the county boards.
All right, thank you. All
Okay.
right.
So move on to staff presentation. Is that where
Yes, yes.
Yep.
I'm going to quickly give a presentation. This presentation's in your packet, so you may have seen it, but I'll provide some comments during it, and then I'll read my staff report. And that will be the extent of the staff presentation. Looks like we might be seeing it in a different color than it previously was, but so the non-conforming status on the Schutz Quarry, 3 criteria are necessary to establish non-conforming status, and I guess I should say before this that there's 2 ways you can have a quarry in an ag district. It's a non-conforming quarry, or it is a quarry, or actually I guess there's 3 ways. It could be an interim permit or a conditional use permit. This quarry has no permit, so it is it is being operated under the pretext of being a non-conforming quarry. In order for it to qualify as a non-conforming quarry, it needed to do all of three things. It had to exist before the adoption of official controls. It cannot have expanded, and that would mean beyond the parcel boundaries as they existed at the time of official controls, and it can also mean the expansion of the intensity of the operation. And finally, that the mine has not been discontinued. If it appears to have been discontinued, that creates a presumption of abandonment, and that must be rebutted. Regarding the existence before official controls, there's a 1947 photo and a 1968 photo that show the quarry. This is the quarry in 1947. This is the quarry in 1968. I don't know why that is the color it is, but we'll proceed anyway. So regarding the criteria, was it lawfully established before official controls? The conclusion staff reached is yes, it was. Expansion, the quarry is located now on a approximately 28-acre parcel. That parcel has been split and joined several times. At the time of official controls, the quarry is approximated here by these two parcels, split in 2013. The footprint in 1968 is approximately 215 feet by 80 feet, so we approximate that at about 0.4 acres, 0.39 I guess to be exact. The 2017 footprint here is approximated at 0.62 acres. Thus, the pit area increased approximately 0.23 acres over 49 years. Therefore, the rate of expansion is seen as very minimal. Staff conclusion on this was that it has not expanded to the extent that it would be disqualifying itself from the non-conforming status. Continual use is the last criteria. Here I'll show you aerial photographs that suggest no activity took place between the 1960s and the 2000s. I'll show you a 1991 photograph of the site in an abandoned state. I'll show you a mine permit coverage history that's consistent with discontinuance. I will show you a MnDOT quarry inventory listing the site as inactive. I'll show you tax status records that are consistent with resumption of activities in the late 2000s. I'll show you a written response from the landowner that indicates that the mine was inactive when he purchased it and has not been continually active under his ownership. And I will show you that the information that the operator points to being the information from prior zoning administrator is very inconsistent with the records that were established at the time the decisions were made, and is inconsistent with the process of addressing other non-conforming mines at the time. Again, here's the 1968 photo. Is our picture out there also blue? Yeah. Purple?
Purple and green.
I might just unhook and rehook.
That's not better.
Well, I'll give it a second. There we go. Okay, so again, here's the 1968 photo that shows the quarry. Moving forward, the next photo we have is the 1991 photo, and the overlay there approximates the quarry size today, and it's added there so that you can get a reference for the size as it changes over time. From 91, we moved to 2003. Again, pictures are not of the best quality, but you can see what gravel looks like on the road, and you can see that the area within the quarry between 2003 and 2004 appears to be minimizing. 2006, it appears to be larger. 2008, clearly larger, and so on up till today. Again, zoomed farther out to get a different perspective to the 1968 photo. The 91 photo, and again we have gravel on the road, a light shade, and a much darker shade in the quarry picture. 2003, appears to be trees encroaching on the site. 2004, appears to be more trees, and then in 2006, again, a larger operation, and the current landowner acquired the land in 2005. in mind. Again, up to present, clearly expanding since 2006 to 2015. So here's two photos, the 1968 photo, and then jump forward 23 years to 1991. The applicant would tell you that that resembles 23 years of continuous mine use. I would suggest that illustrates 23 years of an abandoned quarry. 1991 photograph obtained from MnDOT. Ken DeKramer, he's an engineering specialist with the Minnesota Department of Transportation, shows large trees and vegetation growing out of the quarry, and includes a note on the back saying, weathered limestone abandoned 25 years ago. The area of the pit, if the pit was continually operated since 1967, one might expect it to be larger than 1 acre in size. In 1968, if we approximate the size, we're at 0.39 acres. In 1991, 0.39 acres. In 2017, 0.68 acres. So no increase in pit size from 68 to 1991, and a 0.29 area increase since zoning. Essentially, if we use 68 as a proxy for official controls and current, those are approximations. Permit. So any commercial mining activity requires a state non-metallic mineral permit. It's a general permit that's not issued site-specific. It's issued to one operator, but specific sites are listed on that permit. Permit history on this: the Schutz Quarry is currently covered under the non-metallic mining permit issued to Bonanza Grain. The Schutz Quarry was added to their permit in 2007 reissuance of that permit. Their two prior issuances of permits did not include the site, and going back to 1998, that's as far back as the digital records go, there was no permit from any company associated with that quarry. So that would mean that any commercial removal of material prior to 2007 would have constituted a violation of whatever operator removed that material. Procurements. So we reached out to MnDOT and asked for records of procurements or material testing from the site. They have no records of any materials ever being tested or purchased from that site. Houston County was not able to locate records prior to 2008. We're not disputing that the site was in use in 2008. The area or the time frame that's being disputed is 1967 up until approximately 2006. Since 2008, the county has purchased small quantities of materials. Township data, we requested data from the 4 closest townships. 2 townships did not reply to our requests, and 2 townships indicated that they do not have records that show purchases of material from that site. Caledonia Township has purchased from the applicant, but they have no information as to where the material was sourced. Quarry log notes, again, these are historic documents, but in a 1965 MnDOT document, they list the site as inactive. Tax records. So in 2009, no acres taxed as quarry on the site. In 2012, still no quarry acres taxed on the site. It begins to be taxed as a quarry in 2013, and then is upped to 27 acres later that year. Landowner information. So the current landowner purchased the parcel from the estate of Leo Schutz by contract for deed in 2004. He received a zoning decision in 2008 advising that the quarry was usable. He signs a lease with Kruko Companies in 2009. We sent him, the county zoning sends him requests for information on 3 occasions recently. He visits the office on 3 occasions, and then finally in January of this year, he submits a written response to the request for information where he's asked, what year did you purchase the parcel? He tells us he purchased it in 7/27/2005. He's asked to provide an estimate of the disturbed quarry area. When he took ownership, so in 2005, he says 1 acre. He's asked, was the quarry active when you took ownership of the parcel? He says no. He's asked, is the quarry currently active? He says yes. And if so, what's the volume? You have to ask the operator, he says. And again, we ask, who's the operator? He says Kruko. We ask him to provide an estimate of the current disturbed area. He says 2 acres. We ask, has the quarry been continually active during the time you have owned the parcel? He says no. So the two pertinent pieces of information there are his indication that it was not active when he purchased it, and his indication that it was not continually operated since he purchased it. Operators were also given an opportunity to provide information before county zoning made a decision. They indicated that they leased the property in 2009, that they relied on past zoning decisions, that they provided the records that would show continuous activity in 2008 during the first zoning decision and in 2015, but that those records have since been discarded. That they've operated the site for a decade as a low-intensity quarry, and again, the non-conforming status wouldn't require a decade of use. It would require continual use since 1967. They included an affidavit from the zoning administrator that I'll address in a moment. They further indicated that they operated in the 1990s. Recall that any operation commercially prior to 2007, when it was included in a state permit, would have been illegal. They state that the use of the site has not changed, and all records substantiating continuous activity in the Schutz Quarry were made available to your office in 2008 and 2015. General business records are only retained for at most 7 years. They do not make a clear statement that asserting the site was continually operated prior to 2009. The past letters from county. So 2 decisions were made prior to the one we were addressing here tonight, one in 2008. In 2008, the prior zoning administrator writes, Mr. Miners, the existing limestone rock quarry located on your property in the northwest quarter of the southwest quarter of Section 5 of Winnebago Township is considered to be open and usable as it is currently registered in the Houston County Quarry Log. It is named the Schutz Quarry after a former landowner. Even though the quarry is registered locally, there may be additional requirements set forth by MPCA for best management practices relating to water, runoff of water, sediment, etc. If you have questions, call me. We'll touch on the term registered quarry several times here. There is no reference or no definition to registered quarry in the county zoning ordinance. Keep that in mind. Again, this letter begs the question, why would the owner who has an active operating mine inquire to the county if his mine was open and usable? So the registered quarry list. This is an advertisement that was placed in the newspaper in 1972. It says, any person or construction firm having a rock quarry, gravel, sand, or shale pit located in Houston County, Minnesota, please report same to Register of Deeds, office in the courthouse in Caledonia, Minnesota, no later than August 31st, 1972, purpose being to set a special hearing for rezoning of such areas. Some responses were received from that, and a precursory list was developed. However, the locations of the quarries, the landowners who wish to put acreage on that list are ambiguous, and many times are referred to only by a quarter section. Indeed, this specific site, which is 1 acre in size, is referenced on that list as a 40-acre quarry. The information on the 1972 list was never validated, so there was never a process of distinguishing those who had a legitimate mining operation from those who may have thought it advantageous to include themselves on such a list. It was done in preparation for a hearing, as the advertisement said, and ultimately for rezoning, neither of which ever took place. And the county board did not act to adopt, accept, or bestow any status on the list, nor has the board subsequently taken such an action. The hearing presumably would be where the validation would occur. Do you actually have a quarry, or are you just telling us you do because that might be an advantage to you in the future? So this is the genesis of the term registered quarry. This is the error that I guess is evident in the 2008 letter, where we attempt to grant non-conforming status based on this list, and will again show itself to be evident in the 2015 letter. 2015 letter. And this one is not, interestingly, not to the mine owner, but to the operator. Dear Mr. Kruko, thanks for taking the time to meet with County Engineer Brian Progazinski, Environmental Services Director Rick Frank, and myself at the Schutz Mine in Winnebago Township last Thursday. The reason for the meeting was to discuss the complaints forwarded to the zoning office regarding alleged violations to State Statute 394.36 and the zoning ordinance. As we discussed, the Schutz Mine is a non-conforming mine and has been registered with the zoning office since around 1972. So there you see that we are, again, relying on the 72 list, which does not meet the standards needed for non-conforming status to make a decision as to whether something has non-conforming status. As a non-conformity, Minnesota Statute 394.36, the lawful use or occupation of land or premises existing at the time of the adoption of an official control under this chapter may be continued, although the use or occupation does not conform to the official control. If the nonconformity or occupancy is discontinued for a period of more than 1 year, or any nonconforming building or structure is destroyed by fire or peril to the extent that 50% of its estimated market value, any subsequent use or occupancy of the land or premises shall be a conforming use or occupancy. I understand that you are leasing the property from current owner Gary Miners with the leased property described as follows, and he goes on with the legal description. I also understand that Gary Miners and former owners have retained occupancy and or use of the property as a mine quarry since the original registration by Houston County zoning. So therein lies the problem, in that we're conflating the two concepts of occupancy and use, so that by definition any property would meet the occupancy definition, but the use definition is what we need to be looking at here, because the use is what's in question. The use is the part of the use is the activity that does not conform with the zoning ordinance. It's not the occupancy of the parcel. He goes on, the Free Dictionary defines occupancy as the period during which one owns, rents, or uses certain premises or land. As this property has been historically owned, rented, and used by current leaseholders and past and current owners, it has been occupied and or used as a mine. So if we break that sentence down, he's saying that because this property has been historically historically owned, rented, and used by past and current owners, it has been a mine. That's a logical sequence that doesn't ring true. It doesn't install confidence that there was the correct basis for making a determination on continual use, as I read it, and that's how county staff reached the decision that they did. It does not provide any hint as to what it relied upon to reach that conclusion, and it is interesting that perhaps it didn't include inquiring with the current landowner. Was this an active quarry when you purchased the quarry? Because when we pose that exact same inquiry now in 2018, we get the answer no, which is contradicting what is in this letter. So again, it relies heavily on the 72 list. It does not address establishment prior to zoning. It only takes on the one criteria that's necessary, but to be fair, the one that is in question. It does not address expansion. It discusses discontinuance, but conflates the terms use and occupancy, and there's no explanation of the information that was relied upon to reach that conclusion. So recently, the process that was undertaken in 2014 was recalled by the prior zoning administrator in more detail than he apparently thought necessary to include in the prior decisions. I'll read you some selected parts from this as I view them as pertinent to the matter here. He says that I served as a zoning administrator for Houston County from 2000 to 2005, or I'm sorry, the assistant. I then served as the zoning administrator from 2005 to 2015. Since the 1970s, the Houston County Zoning Office has maintained a list of registered quarries. This list includes non-conforming quarries and quarries operating under conditional use permits. This list was regularly updated throughout the years. In 2008, Gary Miners came to the zoning office requesting a letter confirming status of the Schutz Quarry. I reviewed the registered quarries list, and the Schutz Quarry was registered in Winnebago Township. The Schutz Quarry also had a note state listed, which meant the state of Minnesota had approved this quarry for use in state projects. Recall that when we inquired with the state, they had no records of ever testing material or procuring from the site. It was determined that the Schutz Quarry was a non-conforming mine. This was based on the most current information available, including but not limited to county records, aerial photographs, the registered quarries list, and conversations with other county officials. It was also well known that a number of these smaller quarries, including the Schutz, were being used on a periodic basis. So again, we looked at aerial photos, tonight. They would not, your photo from 1991 would be the same photo in 2008 as it would be in 2018. We looked at county records, for instance, tax records. It was not being taxed as a quarry at the time. It is on the registered quarries list, but we've addressed that already. And the conversations with other county officials, that doesn't speak to the continual operation of the site since 1967. Apparently there was no conversation with the landowner at the time who indicates that it was not active when he purchased the quarry. Based on this investigation, there was no credible evidence that the quarry had lost its non-conforming status. And he issues a decision on February 6th saying that it is open and usable. He continues on May 20th, 2015, a complaint was filed to the zoning office regarding the non-conforming status of the quarry. The complaint alleged the quarry was in violation of Minnesota statutes and the zoning ordinance and must be shut down until a conditional use permit is granted. When a complaint is filed, I investigate the matter and document the nature and extent of the violation. I notified the suspected party of the nature and extent of the violation. I investigated the complaint thoroughly, following the process detailed in Section 10 of the ordinance. I held an on-site meeting at the Schutz Quarry. Took place with operators Gary Kruko and Michael Kruko. After reviewing the site, I reviewed the 2008 decision, historic aerial photographs, and any other records the county had regarding this site. Aerial photographs that were taken at various times dating back to 1960s were inconclusive. The photos that were clear could be zoomed in did show an open existing hole. You had looked at those photos. The photos that are clear are the photos that are after the current appellant took possession of the mine. So again, there's no question as to whether the site was operating in 2015. The question is, was it operating before 2005? He continues, the prior landowners, operators, the Schutzes, for whom the quarry was named after, had been deceased for over a decade, so the county was unable to request any documents or records. Again, I'll remind you to recall the current owner states the site was not active when he purchased it. So it is unfortunate that we couldn't ask the prior owners. We certainly could have asked the current owner. Based on my investigation, the most defensible position for the county in this instance was to confirm the Schutz Quarry was a non-conforming mine and had not lost its status. This was submitted by the current quarry operator, not directly from the prior zoning administrator, and it was submitted in December of 2017. This affidavit is inconsistent with the record or with the letters that were written in 2008 and 2015. Again, the historic photographs that are referenced in the recalling of the process that was undertaken during the prior decisions would be the same historic photographs that you've looked at today, and is inconsistent with a mine re-registration process being undertaken by the prior zoning administrator in the months prior to and after he made the decision in 2015. The re-registration process. So this began in the first half of 2015. The 1972 list is the only criteria applied when granting non-conforming status. Many references to a registered mine. There's no such term in the county zoning ordinance. And it is inconsistent with the affidavit that was submitted in 2017 regarding the process that was undertaken. Here I will read you the letter that was sent out. This is July 2015. To all Houston County mine owners, re-registration of mine and submittal of required reclamation plan. registration of mineral extraction sites, mine or mining sites, commenced in 1972 as an initiative of the county board to inventory the existing mining sites that had been in existence prior to that time. Over the years, these mines have been an important resource for rock, sand, and shale in and around the Houston County area. It has been through the use of these mine sites that mineral resources have been made available for use in road maintenance, construction, and agriculture. These mine sites have also been a valuable resource for materials during times of natural disaster. With that said, it is important that a more up-to-date inventory of these mine sites is done so that the county may have better information regarding these sites, as well as make adjustments to legal descriptions and follow up on reclamation requirements. Based on a 3-year study commenced by the Houston County Board of Commissioners and a 1998 zoning ordinance requirement that requires the submittal of a reclamation plan for any existing sites, the Houston County Zoning Office is hereby requesting a copy of your reclamation plan and an updated description of your mine operation. And he goes on to cite the ordinance language that requires the reclamation plan. Then he says, you are receiving this letter because land you currently own was originally described as a registered mine within county records in 1972. The county's goal is to update these records. So this letter was sent to every single landowner who has property that appeared on the 1972 list that was never validated, a process that began but never completed. In here he says, included in this packet is a zoning ordinance section, is a section of the zoning ordinance that describes the ordinance requirements for a reclamation plan. Please use this as a guide to develop your plan. Please provide a copy of said plan within 6 months. And finally, he says, in addition, please sign and return the registration form as it pertains to your property and your intent to maintain registered status. Sign one copy, return it, and keep the other one for your records. So he is telling people that you're getting this letter because you're on the 1972 list. We've seen the terms registered mine and legal mine being conflated, and here he's attempting to grant legal non-conforming status to folks purely based on the inclusion on the 72 list with no reference of the pre-zoning, pre-official controls requirement, the expansion requirement, or the continual use requirement. And again, this letter was sent out in July of 2015. Accompanying the letter was the form. On the form, it says, yes, I request to maintain my registered status as a non-conforming mine. Name, signature. No, I will not re-register my mine. Name, signature. And then check one. Encloses a copy of my reclamation plan. I will supply a copy of my reclamation plan within 6 months. A mine operation has never existed on my property, and I will not re-register my mine. Therefore, a reclamation plan is not required. My property includes a mining site, but I no longer plan to maintain a registered status as a mine. So with this form that he's asking people to fill out, one could check, yes, I request to maintain my status as a non-conforming mine, write your name, sign it, send it back, and that is the process that was being used to determine non-conforming mine status. That is not the process that the ordinance requires, and that is not the process that state statute requires. These re-registration letters were sent to Black Hammer, Brownsville, Caledonia, and Crooked Creek townships in April 2015. In July of 15, it was sent to Hoka Township, and in August of 14, it was sent to Houston Township. The decision on the Schutz Quarry that the affidavit explains to us how we looked at the continual use requirement, that was the decision. The 2015 decision is bookmarked between bookended between the two letters going out to various townships. So it is very questionable that we made a decision in 2015 based on the proper criteria. We failed to document that in the contemporaneous letters. At the same time, we were re-registering mines based solely on the 72 list, but now in a 2017 affidavit, we recall doing it in a way that none of this other information suggests. So the reliance on the 72 list, we see that in the 2008 letter, we see that in the 2015 letter, and we see that in the 2015 registration letters. The reliance on the correct criteria, we see that in the 2017 affidavit. Again, the criteria for non-conforming status requires satisfying All three of these elements: existence before the adoption of official controls, no expansion beyond parcel boundaries at the time of official controls, and no increase in the intensity of use, and that the operation of the mine has not been discontinued. If it is discontinued, it creates a presumption of abandonment, which must be rebutted. So the conclusions here, the aerial photographs suggest or support inactivity from the time of official controls into the mid-2000s. The DOT quarry log lists the site as inactive in 1965. DOT photograph depicts an inactive site in 1991. The state mining permit coverage doesn't begin until 2007, and there's no record of coverage for that site from any operator prior to 2007. Tax records show that there's no mine valuation until 2013. The current owner states the mine was not active when he purchased, and it was not continuously active thereafter. The operator who's appealing tonight has not yet made a clear statement that they contend that it was continuously operated since 1967, but instead pushes that onto the prior determinations made by the county. And the prior zoning decisions erroneously rely on the 1972 list. The only thing that suggests otherwise would be that the 2017 affidavit, which I've shown severely lacks credibility. So apart from the prior zoning decisions and the affidavits, all evidence supports the conclusion that the mine was abandoned in the late 60s, with activity resuming in the mid to late 2000s. And for the sake of time, I was going to read the staff report, which is short and brief, but I presume you've all had an opportunity to familiarize yourself with it. So if there's no need for me to do that, I will not.
Can I ask a couple questions?
Certainly.
In the letter, the second letter that was put out in 2015, I think it was, there's a implication that some records were lost or destroyed. Is that a possibility, or are records unaccounted for?
Well, I guess I disagree with your initial statement that in that letter, I think that in the appeal letter from the applicants, they suggest that they had records that could have shown, or that did show, that it was continuously operated. They had provided those records in 2008 and 2015. However, we have no file in the office that shows that, and there's no reference to the records in any of the letters, but that they have since discarded those letters.
I have a question. What township is Schutz Mine in? Some of us, we're not sure of the location.
Winnebago
It's
Township.
in Winnebago.
Yeah.
Okay, thank you.
Is there a reclamation plan for this mine on file?
There is.
Are there any other questions? You're done now?
Yeah, if there's no other questions,
The applicant have any comments or information to add?
Yes, I have packets for you guys and inundate you with documents. So bear with me, you may need a break.
We're gonna be covered.
Paper mill, I don't know.
So good evening, I am Michael Kruko here on behalf of Kruko Companies and Bonanza Grain Kruko Rock Products. We are the current leaseholder and operator of the Schutz Quarry located in Winnebago Township. In your packet before you, I have an outline of the different things that I'm going to cover. First, I'm going to go through the 11 points of Aaron's February 2nd, 2018 decision, and then address several other points at the end of that presentation. Because I go through the 11 points out of order, I included on the top a copy for you to follow along with as I jump around. But I will cover all 11. I also have a tendency to speak a little fast sometimes, so if I need to slow down or you guys have questions, just let me know. The zoning administrator's February 2nd, 2018 decision is based on false, misleading, inaccurate, and unreliable evidence. Mr. Locker relies on 11 pieces of evidence to support his decision. I have provided you a copy of this decision for reference as we go through these 11. I will address all 11, but not in the order that they are listed. I want to start with number 3. Mr. Locker relied on a 1965 MnDOT quarry log. This quarry log, if you look up on the top right corner, is dated February 1965. That is 2.5 years before zoning was adopted. As you can see on the next page, that has the adoption, or 2 pages, has the adoption date of the ordinance, August 30th, 1967. And on the next page, though, right behind that 1965 quarry list, in an email correspondence Mr. Locker conveniently left out of his presentation, he asked Mr. DeCramer on February 1st, can you confirm this information that was compiled by the DOT? Mr. DeCramer responded, all I can confirm is that we collected data in the past. It says the highway department, but I didn't generate it, and I'm the oldest person in this department. So, and then a line of question marks. Also, how was inactive determined on that list? What was it based on? Did MnDOT confirm this with the owner? No one knows. And why Mr. Locker would put weight on a list that was published more than 2 years before zoning was adopted is unusual, because even if it was inactive in 1965, as long as it was active in 66 or 67, it meets the requirement to be established as a non-conforming use, as stated in the ordinance section 9.1. Now, if you go to the after section 9 non-conforming uses, you'll see a notice right here. In 1972, the county went through a registration process to get a list of grandfathered-in quarries. The Schutz Quarry was registered at that time and appears on the list, as you can see at the next page. This means that Kate Schutz took affirmative action to register her quarry, suggesting that it had not in fact been discontinued. Otherwise, why else should she have registered it? Now, Mr. Locker argues that this list does not bestow any non-conforming status, and he is correct. But that's because the county does not bestow non-conforming status. It is a property right protected by state law. It is a property right that may be lost under certain circumstances, and the county can prove that. But it does not require a county to bestow it upon someone. Regardless, Mr. Locker acknowledges on the next page in his presentation that the Schutz Quarry existed before the adoption of official controls and therefore meets the requirement to be established as a non-conforming use. Now, relying on the inactive designation is problematic because no one can verify the reason or the data behind it, or why it received that designation, or what inactive even meant. Now, here's another example to demonstrate to you the problem with giving weight to the 1965 quarry log. The next document in this section, as you'll see, is this. In 1990, the Minnesota DNR compiled an inventory of industrial mineral pits and quarries in Minnesota. The report contains the warning on the second page that it does not assume any legal liability, responsibility for the accuracy, completeness, or usefulness of any information, or represents that its use would not infringe upon private property rights. It's the same reason Ken DeCramer from MnDOT wouldn't confirm the information in Mr. Locker in his email, because of this very reason. They can't know how it was compiled, and therefore don't know its accuracy, and don't want to be held responsible. Now on the next page, you'll see the abstract on page 1. The compilers collected data through a questionnaire. Oftentimes when the DOT or the DNR was collecting data, they sent questionnaires to the producers. And those were not required, they were voluntary. Now, if you go to the methodology on page 3, down below in the second to last paragraph, it further states, site locations were not field checked, the authors could not resolve discrepancies or determine the accuracy of the information. Now, if we go to page 5, it does list active, and it's the only place I've seen define what active and inactive means. Active pits and quarries include those that were active, intermittently active, or temporarily inactive at the time of compilation, which means a quarry can be temporarily inactive but still qualify as an active quarry. Now, the last sentence is what's most interesting. Unless current sources identified a pit or quarry as active, it was automatically listed as inactive. Which means if Kate Schutz didn't respond to the questionnaire, it was automatically listed as inactive. The other interesting and why these relying on these old reports is problematic is if you go to the last section on page, it's 107, there's an index of active companies that responded. On page 107, you'll see Botcher Construction, which is in Houston County. On the next page, you'll see Patterson Quarries, Division of Matthew, which is also in our county, and formerly known as Rover Construction, that was also in Houston County. In the 90s, we were also operating a large mining business here in the county, yet we didn't respond to the questionnaire, which means any quarries we were involved with would have automatically been listed as inactive. If the same methodology was used with as the DNR did with MnDOT, then how do we know that inactive wasn't just an automatic designation? Again, relying on those old documents without anybody confirm their accuracy, what was done to confirm with the owners, it's problematic to give that evidence any reliability. So, because we don't know either whether, and MnDOT can't confirm and wouldn't verify the accuracy or the completeness on the list, neither can Mr. Locker. And again, this list was compiled years before zoning even took effect. So based on these reasons, this 1965 list is unreliable. That's for number 3. Moving on to number 4, the next section. On to number 4 and 5, Mr. Locker's reliance on a 1991 MnDOT photograph. This photograph is not of the Schutz Quarry and is therefore false evidence. This quarry in the photo slopes, if you turn to the next page, slopes at an angle of 170 degrees, which results, as you can see, in a very gradual slope. On the next page, the Schutz Quarry, however, slopes at a 157-degree angle, creating a much steeper slope as seen in the picture. Now you may think, 13-degree difference is not that significant. That is until you compare where the slope should be if it matched the 1991 photograph, which is on the next page. As you can see, there is an entire hillside missing. And the 1991 photo also lists, if you go back to the first page, it lists a quarry face of 50 feet. But the Schutz Quarry has a quarry face of 70 feet. So where is the top 20 feet of the hillside? Did it go missing? If you also go back and look at that original photo, it lists Hector Construction and a number next to it. Now, according to Houston County records, so after this page, you'll see a confirmation that the contours of this pit are 70 feet, where it would have been in the 1960s or 1991. It's actually 80 feet the further back you go, so there's an additional 10 feet missing. But if you go to here, Mr. Locker provides records of who owned this parcel over the years. There is no mention of Hector Construction owning this parcel. And if you look at the next document, which is the email from Mr. DeCramer, Mr. Locker asked for information on 2 quarries, 28033 and 28044, but he doesn't provide their names. Now, on the next page, you'll see that 1965 quarry list. There are 2 quarries with the exact same number. 28033 is also the logger quarry, which interestingly enough, as I have circled there, mentions Hector Construction owns, which matches the photo, the 1991 photo. On the next page is the MnDOT records, which also show Hector owned the Winnebago Lane quarry directly to the south of the logger quarry, which is beneath the Schutz quarry. There's 3 of them right there in a row. And MnDOT lists that quarry is being owned by Hector. So what I did was I took 2 photos, one from the Winnebago quarry and one from the abandoned logger quarry, to see if the slopes matched. Well, on the next page you'll see the Winnebago quarry and the slopes match perfectly, but with the 1991 photo. The heights are a little bit off, but Bruning or Rovard may have mined further down after 1991. But what's most interesting is if you look at the last photo, the logger quarry, the abandoned logger quarry. It has the same height of 50 feet, according to Beek and Schneider, as it's stated in the photo. It's obviously abandoned, if you can look at it, and the slopes match perfectly. It was also owned by Hector, according to the 1965 MnDOT list, and it also has the exact same quarry as the Schutz quarry. Mr. Locker never confirmed this data to determine whether or not this was actually the Schutz quarry, because it's not. So he relied on false evidence to take away a property right. And he relied on it so heavily, it's not just 1 point in the decision, it's 2, number 4 and 5 out of the 11. So, the slope of the 1991 photo does not match the Schutz quarry. The face height does not match the Schutz quarry. The dimensions do not match the Schutz quarry. The ownership mentioned on the photo does not match the Schutz quarry. But they all do match the logger quarry, which also has the exact same number. But the 1991 photo is not the Schutz quarry. Mr. Locker put a lot of weight on this photo, but it clearly is not, and so this decision on this ground is based on false evidence. Next, I want to address number 7. That's the next section. Mr. Locker's conclusion that no state or township records of procurements from the site could be obtained. Now, as you can see in the first set of documents, Mr. Locker reached out to 4 townships for records. He reached out to Caledonia, he reached out to Mayville, he reached out to Wilmington, and he reached out to Winnebago. But only 2 responded. But their responses are interesting. Let's first look at Caledonia's response right here. Caledonia states that it only keeps records for 7 years, so going back to 2011, and it lists the vendors who they bought rock from. But Mr. Locker didn't reach out to any of those vendors for records. No, he just concluded that no records could be obtained. Winnebago, on the next sheet, also states that it only keeps records for 5 years, so going back to 2013, and states that the township has never purchased rock from this quarry. But the question is flawed. That is very different from whether or not their vendors have, because the township may not have directly purchased rock from there, but they wouldn't know unless they checked with their vendors. But Mr. Locker just assumed that that there were no records obtained. Now, I do want to note that when we submitted our information on December 15, 2017, we made our records available to Mr. Locker, and he refused to contact us. Now, the townships often buy rock from vendors who operate quarries. They don't purchase it from the direct quarry site. So we offered our records, he declined to speak with us, and so I'm going to provide 2 years of records to show you that townships actually did receive rock from the Schutz quarry. On the next page, you'll see our record from 2008 that shows Mayville Township received rock right there on the bottom from the Schutz quarry. In 2015, Mayville Township also received rock from the Schutz quarry. On this last page, you'll also see a number of hauled to the Caledonia Quarry, CalQ. That stands for the Caledonia Quarry. The Schutz Quarry is a small pit. It's a very low-intense pit. It would not be able to fit a crusher in that space. So oftentimes, rock was hauled out of that to the Caledonia Quarry, where it was then crushed and then sold to townships. Interesting thing, it would be sourced from the Caledonia Township then when referenced on the tickets, even though the rock actually came from the Schutz Quarry. So again, Mr. Locker's conclusion is false. And all he had to do was review our records or ask us, but he didn't want to. The other problem with what Mr. Locker is doing is he's assuming that only townships or the state buy rock. But I think we all know, and as can be seen here in the blacked out boxes, those which are our customers' names, private individuals also buy rock. But Mr. Locker never reached out to any private individuals to try to see if there were procurements made, and he certainly didn't reach out to us. Another reason why a lot of the rock is hauled to the Caledonia Township to be crushed for townships is because townships require tickets, which means the rock has to be weighed. There's no room for the ticket or a weigh scale at the Schutz Quarry because of its small nature. So that's why it has to be hauled to the Caledonia Quarry, crushed, and then sold from that pit. Now, these are just 2 select years that I'm making available, but we've been operating the Schutz Quarry for over 10 years now. But again, Mr. Locker didn't want to review our records. So again, Mr. Locker's conclusion that no records from county or for townships or state could be obtained is false. As I've just shown you, townships did haul and get material out of the Schutz Quarry. Moving on to the next section, number 8. Mr. Locker's conclusion that no county records of pre-2008 procurements from the site could be obtained is extremely misleading. In an email, as you'll see right there on the top, Mr. Locker emailed the county to receive procurements records from them. And I'm going to read Mr. Progodinsky's response. I talked to my senior advisor, my senior staff, and looked in our Schutz Quarry file and could not come up with any specific projects that used rock out of there prior to 2008. That does not mean we didn't. And the only way to know for sure would be to pull out every single project file we have separately and look to see where the rock came from. However, that would take a lot of time to go through, and since our record retention requirements don't require us to retain scale tickets for that long, the highway department has cleaned house a few times, so there's a good possibility that any details on that quarry would no longer be available. Then he goes on to state, since I came here in 2008, there has been a little rock used out of the Schutz Quarry for maintenance projects, but no large-scale projects. And this is coming from the county engineer. Seeing the overall size of the quarry, my best guess would be that the quarry was not used on large-scale projects, but may or may not have been used during small maintenance-type projects. That is very different than stating that there were absolutely no records that could be obtained. It is misleading to state that, because the county doesn't have records. They didn't go through to see if there were small maintenance projects, which is more likely than not what the county would have used the rock for. Because again, the Schutz Quarry is a low-intensity quarry. It wouldn't be used for such large-scale pits. On the next page, there's an interesting note on Mr. Locker's work product. He states, review of county procurements back to 2005 do not show any material from this site. But I'm just providing you records now that show the county hauled material out of the Schutz Quarry in 2008. So how can he state that there were he reviewed them and no procurements going back to 2005 in his notes, but if he would have just asked, he would have seen that in 2008 we were in fact, the county hauled 175 truckloads in 2008 alone. So again, the statement is misleading. Not having documents is very different than saying no documents exist, which means it likely wasn't being used. So Mr. Clocker's conclusion here is misleading as well. Next, I want to move on to number 9. Mr. Locker's conclusion that no state materials testing records for the site could be obtained. This is also a misleading conclusion. The state does not test every rock quarry. It's not something they would ever do. It would be unreasonable and time-consuming for them. They would only test material if they were going to use rock from that quarry for a state project. The state, however, is not the only one who does material testing. In fact, we use a private vendor to do our materials testing on our quarries. But again, Mr. Locker kept his investigation to only government agencies. But again, they are not the only purchasers or users of rock materials. Now, Mr. Locker made a comment that the 1972 list has state written next to us, meaning it was state materials tested, as Scanlon wrote in his affidavit. But Mr. Locker doesn't want to rely on that list for anything, but he wants to rely on it selectively for certain things that fit his conclusions. But again, why it was listed as state on that list, you'd have to ask the people who conducted and compiled the list in 1972, which, does anyone know who it is? No. So again, the fact that there's no state testing records, which means that it was discontinued, is inaccurate. The state would only need to do testing materials if they themselves are going to use the rock for a state project. The next section, number 6. Mr. Locker's conclusion that the site was not covered by a non-metallic mining permit from 1998 to 2007. And his statement that, in the decision, that it may never have been covered by a non-metallic mining permit. That statement is blatantly false, and Mr. Locker knew it. Because in the email that he received from the MPCA on January 3rd, 2018, as you can see on the first page, the MPCA confirms that the Schutz Quarry has been covered under our non-metallic mining permit MNG 490087 since 2007. So the fact that it may never have been covered under a non-metallic mining permit, the MPCA told him it was. Now, Mr. Locker then asked Stephen Speltz on the next page, if we had hauled rock out of the site in the 1990s, would doing so have been a violation of our mining permit? Mr. Speltz said yes, but they are overlooking one key fact. The Schutz Quarry arguably did not even need a non-metallic mining permit until we became the exclusive leaseholder. Because a non-metallic mining permit, also known as an NPDES SDS, is required for construction activities. Now, at the time, construction activities is defined in the next section, and it references back to here. Those reference construction activities that would fall under them. So to define construction activities, you have to go to the definitions page. Under construction activity, grading, excavating that result in land disturbance of equal to or greater than 1 acre would require a non-metallic mining permit at that time. So the Schutz Quarry was always under an acre. It still is. It's still under an acre in size. Now, at the next line, it says, including the disturbance of less than an acre if the total area of land is part of a larger common plan for development, right? Arguably, the Schutz Quarry would be that because we're going to increase the pit as we extend over the years. But that requirement for smaller areas that are part of a bigger plan, as we look at the next page, according to MPCA, didn't become effective until 2003. So arguably, if the Schutz Quarry was being operated by the Schutzes as a small pit under an acre, and if they didn't have any necessary any plans to increase it by more than an acre, they would have they wouldn't have needed to get a permit. So that conclusion is also false.
Could I get some clarification?
Yes.
So this permit would have been required starting in 2003, is that correct?
Well, when we took it over, when we took the pit over, we knew that we would, because of the long-term nature of the lease, because it's a long lease that we have with Mr. Miners, that eventually we're going to increase past the 1 acre mark, which means we would require to get the permit. We decided, let's put it underneath our permit right away. which is what we did.
So, but it would start being required in 2003, is that correct?
It would need, that's when they changed the law to change it to where it needed to be larger, a part of a larger plan. But we don't know if the Schutzes intended it to be larger than an acre or what their plan was.
When did your lease start there?
The lease was signed in 2009, but we did shots in 2008, and it was put under our MPCA permit in 2007. And when we took it over, that's when we knew that eventually, over the years, we would increase more than an acre. We took proactive measures then to put it underneath our MPCA's permit, our non-metallic mining permit, at that time.
So it started getting permitted under this non-metallic mining permit in what year?
In 2007. So, we don't know what the previous owner's plans were. Maybe they never intended it to go over an acre. We don't know. But what's interesting is I provide a copy. Well, and as you can see on the next 2 pages, I provided this because this is what the MPCA provided to Mr. Locker. Construction activities was eventually changed and housed under industrial classifications. And so these things change, these rules update, they change that stuff. So no confirmation was done to see what were the rules in place at the time and whether or not the size of the pit needed a non-metallic mining permit. But what I do here is I also provide you a copy of a general permit, our general permit, which is right here. Now, in this permit, it talks about on page 3, non-metallic mining and associated activity compliance audit. Sorry if I'm jumping around through pages, just let me know. There it says, not sure if you need a permit. The audit is intended to be completed for facilities that that conduct any non-metallic mining and associated activities that do not have a permit, but wish to evaluate whether or not they should have coverage. Which means that maybe they should have done a coverage determination whether or not it needed to. But saying it was a violation of our permit when we hauled material out of there in the 90s is also inaccurate. We never stated that we operated the quarry in the 90s. We stated that we hauled shot rock. Shot rock is when you blast and there's these big boulders, and oftentimes it just lays there until it's hauled to a crushing equipment or if you have fill to do. Well, we hauled rock out of that pit in the early 90s, shot rock. It was hauled, just like we do now, to our Caledonia quarry where it was then crushed. We were never the official operators of that pit, though. So we never needed to put it underneath our permit.
Who did have it, who would have had to put it under their permit?
It likely was owned by the Schutz. It was an owner-operated Schutz quarry. So it would have been their responsibility.
Did you ever check if they had a permit?
No. When again, if it was under an acre in size, it wouldn't have even needed one. So there may have never been a definitive plan by the prior owner to increase the pit more than an acre, which makes whether or not a permit was needed back then questionable. But when we took over the pit on a long-term lease, we knew it would eventually increase more than an acre, and we immediately added it to our permit. And on the back, I also include a copy of our permit renewal. So, and it lists the number of sites that we have posted underneath our permit, mainly because it was accused that it may never even had a permit, so it did. Moving on to number 10. Mr. Locker's reliance on tax history. Prior to 2013, the site was part of a larger 75-acre parcel. When the parcel was split in 2013, the county started taxing it at 5 quarry acres and then 27.35 acres. As you can see, it was part of a 75-acre parcel. The next email confirms that from Cindy Cresswell that it was split in 2013. And then you see Mr. Miners' tax records where he was being taxed at 28 acres. The entire parcel was being taxed at that rate. What's interesting about that is This is it was the highest tax quarry in Houston County for several years. For whatever reason, the Houston County assessor assessed it as entire quarry acres. Now, normally how Houston County does it is they tax the open pit and then additional acres as the quarry increases. For whatever reason, that was not done on this pit. So Mr. Miners overpaid in taxes for several years.
Can I stop you for a second?
Yes.
The issue seems to be what happened prior to the time that you got it and owned it, and all of the stuff that happens after that really isn't an issue for us.
I will get to that. I'm
Oh,
just going through
well-
Mr. Locker's points.
Okay.
So I'm showing that his points are unreliable or false or misleading. And because his decision of continuity is based on those 11, I have to go through all 11. Even though I know you want to just get to the main 1 and 2.
Yeah, okay,
Yeah. But for the record, I have to go through all 11.
okay.
So,
For the record.
yeah.
Another clarification. You're saying that this whole 28 acres was taxed?
Yes.
So, but no one was committed to mining more than this half acre or approximately. That seems kind of contradictory.
I'm confused.
Well, why would they tax the whole 28 acres
That's
if
a
there was
question.
no intention to mine more than this half acre or so?
That's the question for the county assessor. We have no idea why it was taxed at that rate.
And once again, the zoning department is not disputing anything that's happened after 2000.
No, but he's using it as grounds to justify his decision. And I'm gonna show you
Okay.
why using
But I
that
mean,
as
we-
grounds is problematic.
I got you.
So, Mr. Locker states that because it wasn't being taxed prior to 2013, that means it suggests it wasn't active during the previous years. But under that rationale, in 2008, 9, 10, 11, 12, it wasn't being taxed as quarry acres, he admits it was active. So again, just because it wasn't being taxed as a quarry acres doesn't mean it wasn't an active pit. Because under that theory, we wouldn't have been active in the years that we obviously were. And this ain't the first time that the county overlooked this. On the next tax records, 04025300, this is tax records for a legal non-conforming mine, Fred Kruko's Reno pit. It was case number 28CV15770. The site was not taxed as a quarry up until 2016, as you can see, when its valuation jumped from 22,000 to 48,000. Mr. Kruko received a letter from zoning stating that he didn't have a non-conforming mine because it didn't appear on the registered quarries list. They provided evidence to the Board of Adjustment, but no mention of the fact that it was never taxed ever came up from the county. It was never used as a factor, that the property was never taxed at quarry rates, yet it got to maintain its non-conforming status. So tax determination is not determinative of whether or not it's being active, because the county has a history of not taxing active quarries that get to maintain their non-conforming status. Now, the next few pages are the overtaxation, which led to Mr. Miners requesting a tax abatement for 2014, 2015, 2016, and 2017. On February 6, 2008, and I have the meeting minutes there, Mr. Miners' abatement came before the Board of Commissioners. Interestingly, at that same meeting, before Mr. Miners' tax abatement issue came up, the board heard Mr. Locker's presentation that he gave here today, where he shut the quarry down. But then shortly thereafter, the board voted to approve Mr. Miners' tax abatement and still tax it as a quarry, even though they had just heard Mr. Locker's decision that it was not a quarry. They voted to approve it still being taxed as a quarry. And if you look at the quarry, at his current tax records, it's still being taxed properly as one rock quarry acre. So Mr. Locker's conclusion is not a determinative factor in continual use. And his logic is faulty, as he acknowledged that we were active in 2013, even though the county was not assessing property taxes at that time. So on to number 11. Mr. Locker's reliance on Gary Miner's response to his request for information. The problem is not with Mr. Miner's answers. It's with the questions that were being posed to him. They were vague, not specific as to timeframes, and can be interpreted in many different ways. And Gary Miners is a good man, but he's not a lawyer. He's not a miner who's familiar with the terms. Was it described to him what inactive and active meant and their legal consequences of that? Was he advised of anything that was going on? All it looks to me is he didn't know a lot of what was going on, and he says a lot of don't know, ask Prukos, and there's no statement that shows discontinuance for a 12-month period. And if Mr. Miners took ownership in 2005, Mr. Locker's aerial photos, which we'll get to, show activity picked up then. So how could his answer be that the quarry wasn't active when he took ownership, yet the aerial photos show activity was increasing? There's an inconsistency there, and we'll get to that.
Is Mr. Miners here?
Yes.
Who are
But
you?
whether he wants to talk or not, I would say he should probably have a lawyer involved based on the inaccuracies and false information that was presented here.
Does Mr. Miners want to answer a couple questions, whoever you are?
I just want to listen. I've got my own thing to say. So.
Okay.
And again, Mr. Miners relies heavily on us too, because if you look, he says that the quarry is 1 acre and it's 2 acres now. It's still under 1 acre. So it's best to always contact the vendor or operator because they're going to have more of the information known, which is pretty much what Mr. Miners alludes to in his decisions and his answers. But there's no time frame stated that meets the 12-month requirement to prove discontinuance, which Mr. Locker needs in order to show that it was discontinued or prove that. And if we go to the next page, Mr. Locker's work notes, there's inconsistencies in his notes. For example, on January 25th, Gary Miners visited him. He provided written responses to the questionnaire indicating that the quarry was not active when he purchased the property and that activity did not commence until after he signed the lease with Pruco. But we know that's not exactly accurate because the lease was signed in 2009. We were shooting in 2008, and it came underneath our MPCA permit in 2007. And I believe at the time, Mr. Miners, the reason he requested that letter from your office is because we were having the lease drawn up and the lawyers wanted confirmation that we could do this. So again, you oftentimes will ask zoning for things like that to get confirmation and make sure that these documents that we're entering into are legit. Further down though, on his January 18th meeting with Mr. Miners states that he does not know how the site was operated in the 70s or 80s, or the 70s, 80s, or 90s, and that he feels Mr. Locker is interpreting things different than Mr. Scanlon. So again, there's no definitive statement of a 12-month period of discontinuance. There is no explanation to Mr. Miners what discontinuance means, what inactive means, what any of those technical terms are. Moving on to number 2, the one that I think you'll find interesting, Mr. Visker. Mr. Locker's conclusion that the open pit is only 0.29 acres larger today than it was in 1968. In 2008, we did 3 shots that increased the area of the Schutz Quarry. And I provide those blasting records. We did 1 shot on July 31st, 2008. 1 shot on September 16th, 2008. And another shot on September 19th, 2008. They're all very small shots. That's typically what we do. It minimizes the impact that a shot would otherwise have. And again, this is a low-intensity quarry. Now, if you look at what Mr. Locker provided for intensification on his slide, Mr. Locker estimates that the area of the Schutz Quarry in 1968 was 0.39 acres. But where are the measurements based off of? There is no scale to this photo. How did he determine what those measurements were? And
So
if you
can we ask him?
Yeah, I'd like to know.
If there's a scale on the, those are film photographs, and on the key to that, there is a scale. So I work
So
with
you
them.
took an old 1968 photograph, implemented it into a new policy, and measured it up, right?
I'm going to answer that.
Yeah.
Yeah. Yeah, I worked with the county surveyor to get a scale for that, so we could do
Why is
precisely
the
what we.
scale not provided?
I'm sorry.
He's saying, why is the scale not provided?
In the PowerPoint presentation, I guess I didn't think it was necessary.
But it wasn't in any of your work notes either.
Again, I guess I
But
didn't think it was necessary.
Interesting though, if you do his calculations, let's take his calculations. 215 feet across and 80 feet wide. His calculation does not add up to 0.39 acres. And here's why. You can tell it's an oval shape. How you determine the area of an oval, you take pi times the radius times the other radius, so 80 times 107.5. You get that, you divide it by 43,560 square feet per acre. You divide that by 2 because you only half the oval, and you get an area of 0.31 acres. So again, his own estimates don't add up.
Who computed the acreage?
Yeah, I computed. Those are just approximate. I think I used the word approximate several times, and I'm
I
presenting to you.
don't
that-
see approximate on any of these data.
But the
Well, I
surveyor
mean-
did not.
No. And the difference, the delta between what he arrived at and what I arrived at, I don't think that those are game-changing differences.
0.31 and
It's approximate.
0.39 on a slow intensity quarry. A quarry that would be increasing at 0.0054 acres under historical rates. You don't think a 0.8 difference matters?
In terms of the context of what we're looking at here tonight, I don't think that
I
has any
think that's a
relevance.
part of our determination.
Well, let's continue, because if we go to 2017, Mr. Locker uses Feek and Schneider to make his determination. And it tells you the area of the pit, and it lists 0.62 acres. Now, if this calculation is right at 0.39, and 0.62 is what it is in 2017, our 2008 shot would have doubled the size of the quarry, but it didn't. As you can clearly see, I highlighted in yellow the area that our shot increased. So I used his exact same software program right here to measure how much of an increase our shot in 2008 did. It was 0.108 acres. So the actual pit increase in 2008 only 0.108 acres, which means for Mr. Locker's numbers to be correct, the pit was increasing between 1968 and 2008. How else do you account for those other numbers? Now, because another shot to increase this pit will likely not be needed for another 5 to 10 years, the current average annual increase is only 0.0054 acres. And if you look at Mr. Locker's intensification map, he uses square feet, but when you convert that to acres, it's 0.0047 acres.
Can we stop again a minute?
Yes,
We're doing a lot.
I know.
I would like to ask Aaron, your measurement of the 1968 acres and the 1991 acres are the same. Did you use the same process for those so that you're comparing apples to apples?
No, the 91, or I'm sorry, I believe so. I guess I don't recall exactly. The measurements that are provided in the PowerPoint presentation are approximate measurements. So I'm not looking to do an oval versus a rectangle. I'm just trying to give you an
I guess my
approximate number.
point is, if there was no significant expansion, and according to this numbers, no expansion between 1968 and 1991, what happened?
Well, here's the thing. When we took over in 2008, right, we did one shot. In 20 years, that footprint will not be increasing. In 20 years, not an increase in footprint, because there's that much rock there. right? Does that mean that the quarry is inactive during these last how many years? No, it's absolutely active. It's
How
just
many
the
yards are
footprint.
come down in a shot?
That I do not know.
But
But-
again, intensification is not an issue.
No, but it's one of the bases that he uses to shut the quarry down for discontinued use. It's number 2. And here's the other thing, on his list
Excuse
of
me.
calculations.
I thought that that wasn't an issue.
We're not saying that it expanded or intensified. We're saying that it
that's
didn't
not
operate
it.
from the 60s until 2000, mid-2000s.
But that's not an issue in terms of, didn't I hear you say that?
Correct. I agree
Okay.
that it has not
Okay.
intensified or
But he
expanded.
uses it as number 2, as grounds to justify discontinued use.
Well, I think what he's saying is, I'm not saying that it doesn't meet the non-conforming use criteria due to expansion, but I am saying that if you look at the size of it in 1968 and you look at the size of it in 1991, the difference between those photos does demonstrate that it was
But
discontinued.
Here's the interesting thing. Where is the 1991 photo that he used to get that area? Now, I see the 1968 photo. I don't see the 1991 photo that he uses to get the area.
Yeah, you don't have it with the measurements on there. I guess you'll have to just look at the photo and
Where is it? What 1991 photo? The blurry one that I'm about to present? There's no way you could have determined area based on that and those calculations. Or did you use the 1991 MnDOT photo that's not actually the Schutz Quarry and use those dimensions?
Well, the blurry one is blurry because the area of the current quarry is put over the top of it. I'm assuming he has a photograph without that put on top of it. Is that correct? or-
it's available. That doesn't make it perfect. For those older photos, you're mainly looking for the
And
color
we'll
of
get to those-
vegetation
we'll get
versus
to
the
those
color of
blurry
gravel.
photos in a second. But again, he has not provided the photo that he's used and how he determined 1991. If he used the MnDOT photo determined based on those dimensions, well, we know that's not even the Schutz Quarry, so that would be false. And why he would not include, he includes the 1968 intensification photo to determine, but he doesn't include the 1991 photo? And again, in 20 years, the footprint of this quarry is not expanding, right? So if there was rock sitting there, it wouldn't expand the quarry footprint. That doesn't mean it's inactive.
You said that one shot is good for 20 years. I don't know how you could say that. You don't know what the demand is gonna be in 20 years.
Well, you don't, but based on current usage, we did one
I
shot
think
in
that statement was kind of,
well, we did one shot in 2008. There's still a ton of rock sitting there. And based on the current rate that we're using it,
to use the shot as a basis of your expansion when you don't know the demand is,
Well, see,
you can't use that.
we have to keep it under a certain amount, otherwise he'd argue that we are increasing the intensity and thus lose our non-conforming status under that ground, which is why it's being kept at such a low usage. Because otherwise it's a grounds to lose your non-conforming status, which is why it's being maintained at a low usage rate. Now to the aerial photographs. Number 1, his reliance on various aerial photographs, including that the open pit was minimizing over time until 2006. So he provides the 1968 photo where you see the open pit. Then he uses a 1991 photo. Now, as you can see, it's pretty blurry. I see that he puts his outline on it so it lightens it a little bit. But the photo itself is blurry. It was taken in April of 1991, so there was no vegetation, which probably will also affect its shadowing effects. But you can't see any activity because it's an aerial photograph that's blurry. You wouldn't be able to see any activity. But this was all he had to rely on. Then you look at the 2003 pit. Now, you also see the open pit there, and there's also more vegetation and green growing. And then you look at 2004, I mean, that thing is so pixelated, you kind of see the outline, but I would argue that relying on that to take away someone's property right is a stretch. Now, moving on to 2006. the next page, we see a more clear open outline. And then the 2008 and 2009. Now I'm going to show you why it's problematic to rely on these kind of aerial photographs. You look at this. If you compare the 2003 to 2004 to 2006, it appears to be expanding. But Mr. Locker claims there was no activity going on at this time, prior. But the photos suggest otherwise. How can it be increasing if there was no activity until we took over? I don't know. I mean, but neither does Mr. Locker, and the photos suggest something else is going on. It's likely because the shadowing and the aerial views are blurry and they shadow when you take things at this height and you zoom them in to this degree. I'm going to show you something else. Now in 2011, 2013, and 2015, he also shows aerial photos of our current pit that's being active. Now, if you look at and compare the 2011-2013 pit, you'll notice I circled in red. It appears to be getting smaller from 2011 to 2013. Well, that's weird. How can the pit be getting smaller if we're active in it? How is it that the pit is smaller when we're continually growing it? It's because of the shadows, the vegetation, and the blurry effects that are created when you use aerial photographs like this. Now, I also received some documents that Mr. Locker did not present to you guys, that he was also using Google Earth to make determinations on this quarry size. In 2003, he lists the quarry at 0.13 acres, and you can see he outlines the little pit there. In 2006, he says it increased to 0.39 acres. But then in 2008, his calculations say it went to 1.3 acres. But then in 2015, it went back down to 0.71 acres. Well, how is that possible? Again, relying on old photos zoomed in to this scale, it creates inaccuracies, unreliable evidence, because these then don't sync up with what Mr. Locker is saying. And if you look at the following email with Darren Wilkie, I think this one's most interesting. Mr. Locker talks with Mr. Wilkie and he says, Mr. Locker says, my struggle is in determining whether a quarry site has been discontinued. My ordinance states that legal nonconforming status is lost after a discontinuance of 6 months. If I were to narrowly consider only extraction activities, most sites would not meet this standard. On the other end, it is likely there are sites that were not used for 10 to 30 years. In speaking with Jay Squires, he advised an approach where I determine what typical quarry usage is in the area and measure that against a specific site. That is to say, if a non-conforming site was not being used at the same rate as a typical site, that would be considered discontinued, and a CUP would be required. But not all quarries are comparable. Now, we don't argue that the Logger quarry is abandoned, but Bruning's quarry further south is one of their main quarries and has been active in increasing at a larger rate. You can't use that typical quarry usage to compare the Schutz quarry, which we've acknowledged. It's a small quarry pit. So why he would use that as proof that this pit lost its non-conforming status, it's questionable, because the two quarries, or whatever quarries he's comparing it to, are not necessarily comparable. And one thing I did pull is two GIS reports, or maps, that they did. One in 1984, right here, and one in 1990. You look at the close-up of the 1984 one, you see that they list two active quarry sites. Right there and right there. There's one missing. What one is missing? The Logger quarry from the 1991 photo. The fact that it's not on there suggests it was removed for a reason, but the other two remained on there. Same with the 1990 photo.
Who took these photos?
This is from the USGIS mapping service. They also list two quarries, if you look closely. The Schutz quarry and the Lane Winnebago quarry. Not on there is the Logger quarry. The fact that that quarry doesn't appear
How do we know which quarry is which?
based on their locations. Right up here, the first one, that's the Schutz quarry, right there at the end of the driveway. Down, right at that hump in between the two, that's where the Logger quarry is. And right below that, that's where the Lang Winnebago quarry is.
And why? Am I looking at the wrong page?
Which one?
Is it this one?
You're supposed to be looking at this one, I think, Ken.
The one before that.
This one? Oh, and these are the, okay.
Yeah. You see they have a little, little
That's
digging
pick-
things.
I got it.
as,
Pickaxe.
Supposed
quarries,
to,
yeah.
that's the quarry.
And the one on the
symbol, right?
top is what?
That's the Schutz quarry.
And the next one is,
The next one that's shown is the Winnebago Lane quarry.
and where's the Logger quarry?
Exactly, it's not on there.
Where is it though?
It's in between the two on that hump.
So why is it not there?
Because it was abandoned. That's the quarry from the 1991 MnDOT photo, and it was removed from the list. So what all those show is that there's inaccuracies, especially when you rely on blurry photos that are zoomed in, and they don't account for things like shadows, vegetation, and we have no idea what's going on the ground. But that's all Mr. Locker had. Because to lose or prove discontinuance, to take away someone's non-conforming right, the county has the burden to prove discontinuance for a period of 12 months. But all Mr. Locker has is the 1991 photo that's blurry, a 2003 photo, and a 2006 photo, but when you look, something's happening between there. So all he has is a random shot in time, nothing consistent, not on an annual basis, on a monthly basis to compare, because who knows what was happening before or after that. We can assume, but based on all we have that's not been false, misleading, or inaccurate, are a couple aerial photographs. That's it, to prove discontinuance and take away Mr. Minor's property right. All the photos suggest is that this is what it is, a small, low-intensity quarry that we have nobody knows what was going on between 1968, 1991, which also includes a MnDOT photo that's not even of the Schutz quarry. And we went through all 11 pieces now, and every one of them are either false, misleading, inaccurate, or unreliable. And he's not established a 12-month period to get the presumption of discontinuance. So, it should also be reminded that it's generally policy by the courts in Maleko Partnership versus City of St. Paul to favor property owners' rights and their interest in the continuation of their non-conforming uses, especially when all you have really to rely on are a couple aerial photographs. Now, I'm going to get to the decisions now that we previously relied on. So those are the 11 points of Mr. Locker's decision that he's based on. The fact that it's even based on a false photo, that taints the entire decision itself. But let's move on to the equitable estoppel argument. So this case presents a classic case for estoppel. And estoppel is a legal doctrine that is intended to prevent a party, in this case, the county, from taking unconscionable advantage of their own wrong by asserting strict legal rights. And there are 4 elements that need to be met. Wrongful conduct on the part of the authorized government agent, a party seeking equitable relief that relied on that wrongful conduct, the party incurred expenditures in reliance of that wrongful conduct, and
Are you just laying a foundation for future appeal, or are you asking this board to make a decision on equitable stop?
I'm raising the concern to address the decisions that were made, and also to lay the groundwork if we need to appeal this.
And you understand that they can't rule on equitable stop.
Do you have case law to support that?
It's not in order.
It does. It's case law, Mr. Riyad. I have.
What I'm just telling you is that, is ask a question. You're just laying this for
In Beatty versus Minnesota Board of Teaching, the court talked about how boards in their quasi-judicial roles
There you go.
have the right to apply estoppel.
Do you want to hear what Sam's opinion is on this?
Yeah,
Maybe
yeah.
we should let him talk and not be interrupted.
He's the attorney and we'll go by his advice.
So,
And
and-
we can't rule on this.
Mentioning that, in the February 6,
Wait a
2000...
minute, wait a minute. We want to hear his advice.
Oh, okay.
What I was just saying is that I do believe Mr. Krukow here, if he is going to make a record for appeal, that I can understand that. But as far as this board ruling on the equitable estoppel argument, that's for this board to decide if they want to hear that or not. I personally believe that it is a issue that's more properly brought before the district court, but that's up to this board if they want to hear that or not.
Do you have case law to support that?
No.
I actually
Wait-
have a
wait a
comment
minute.
about that.
We will go with our attorney's advice.
Mentioning that, I'd like to ask a question. In the February 8th or February 6th hearing before the Board of Commissioners, Commissioner Arnold talks about Mr. Yant's close involvement in Mr. Locker's decision and how he helped him prepare for that presentation. Is Mr. Yant representing Mr. Locker here and then also advising the board on a decision he also helped him advise on?
He's representing the county.
Interesting.
That's what he should be doing.
But it appears to be a conflict, though. How can he give legal advice to a board that's supposed to make an independent decision when he also provided that same legal advice?
Can I comment on this?
Yes.
I did consult with an attorney on this, and I was given this information. Nor is it an agency cannot be stopped from enforcement of its statutes merely because of ineffective prior enforcement. If that was the case, then you could never finally get to the point of enforcement.
But here's the thing, and you're correct. If it was a simple mistake, right, then we can't argue estoppel, right? There needs to be
We're not going to.
wrongful conduct. But I need to lay the groundwork. And Mr. Locker challenges those prior decisions, which I also need to raise concerns about what he said about those prior decisions.
All right.
Which prior decisions are we talking about now?
The 2008 and 2015. So, one thing that you'd have to show is wrongful conduct. And if you look at Mr. Locker's staff report, he proves that there was wrongful conduct if he's correct by stating, "It is inconceivable that the evidence regarding usage of the site as a mine from 1968 to 2006 would change so drastically such that in 2015 it would support a conclusion of continual use and in 2018 a conclusion of abandonment." That suggests that Mr. Scanlon committed wrongful conduct, more than just a simple mistake if it's inconceivable. But Mr. Scanlon didn't rely on false evidence. He didn't rely on inaccuracies. Mr. Scanlon, if you look at his affidavit, he states he looked into things, but there was no conclusive evidence where he could support a finding of a 12-month period of abandonment, which is what he had to show. That's why he ruled the way he did. Now, I understand Mr. Locker doesn't like that decision, but if you look at, and I include this for the record, the 1972 list, right? We know that the county took action to register quarries. Mrs. Schutz took
Hold
affirmative
on.
action.
Hold on. It's my understanding. It's my understanding that we are not ruling on whether or not the ruling was accurate or not. We're ruling on Mr. Lacker's process and whether or not he did due process when he made his decision. That's my understanding of what we're doing. We're not adjudicating, or whatever the word is, whether or not this was a correct decision. We're ruling on, do we feel that Mr. Locker did due process, that he did what he needed to do?
So,
And then the rest of that will be adjudicated by a court of law.
But in order to adjudicate it, you have to bring it up at this level to create the record. Otherwise, they
Okay.
will argue that they can't bring any of this stuff in because it
Okay.
wasn't made part of the record.
Chair, if you, perhaps you can inquire with the county attorney if written documents could simply
Mr.
be
Locker.
submitted to get it into the record, because we have, the entire packet that you have before you was submitted for the record before the presentation began.
Well, let me ask.
Would that be
So that's
consistent, would that get it in the record?
So the question is, can Mr. Krukow establish his record via his documents, or should he be able to present, even if you may not rule on it? That's up to you or not. But whether he'd be able to continue to receive, sort of, provide an argument. Again, that is up to you. I do believe Mr. Krukow is correct, that he needs to raise these issues at this hearing, perhaps to preserve those, but whether this board wants to take the written documents, or you want to hear more presentation from Mr. Krukow, that's up to this board.
And submitting the records will satisfy the requirement?
I don't know what those documents are that Mr. Krukow has. I guess that's a question you would have to go over with Mr. Krukow.
Are you satisfied with that?
What would you like me to do?
Are you satisfied with simply submitting the records?
I will submit them and not talk about the estoppel. I raise it, but I do want to talk about the inconsistencies that Mr. Locker challenges with the prior decisions, because they're actually not accurate either. And if I may do that, since he challenged the decisions, I'd like at least the opportunity to show how they're not actually inaccuracies. I think that's only fair.
I'm good with that.
Yep. I'm good.
All right.
So in 2008, we had a decision made, and we relied on that. And then in 2015, when Mr. Scanlon was going through the re-registration process, at that same time is when they received a complaint against the Schutz Quarry from the same group of complainants. Now, because a complaint was received, Mr. Scanlon took extra investigation that he didn't do with other quarries. It doesn't mean that it's inconsistent with what they were doing. They were re-registering. But just because they were re-registering the non-conforming status, that doesn't mean that they were giving non-conforming status. They were just updating their quarry registration list. This complaint addressed the very whether or not we had a non-conforming mine. And so Mr. Scanlon met with us. We met at the site. We showed him anything that he asked to see. And according to his affidavit, he looked at things. And as you can see, it wasn't just the 1972 list. He talks about how he looked to see who owned the property before, who were the prior owners, had it been occupied and used as a mine. Maybe he didn't lay out the 11 grounds that Mr. Locker wanted him to, but that doesn't mean that Mr. Scanlon didn't. And what we did was we simply asked him. We asked Mr. Scanlon what he did, rather than Mr. Locker didn't want to ask Mr. Scanlon. Why wouldn't you ask the zoning administrator at the time what actually he did?
Did he have supporting documents for his conclusions?
Yes, whatever was available to him, and according to his
Do you have them?
affidavit, that's what he relied on. Now,
Do
interestingly,
you have them? Can we see them?
you'd have to ask Mr. Scanlon.
Okay.
And he was a county employee. If there were records there, the county should have them. But here's the other interesting thing. When Mr. Locker was investigating this pit, we raised that there was a 2015 decision. And he talks about how there was no other records in his file. But he then states in an email, November, that he didn't even know that that prior decision existed. So how is the county retaining records if they don't even know prior decisions existed? And when does a decision become a decision in this county? How could anybody rely on anything if the new zoning administrator can just come in and say, I disagree with what my prior administrator said?
Well, I'll probably get myself in trouble, but my view of that is that was, as our Mr. Locker said, his opinion at the time. Had they gone through the process of getting a conditional use permit, that's when it is reviewed, it's investigated, and that's why you go through that process, because you have public meetings, you have the investigation, you have the documentation. So that was the zoning administrator's opinion at the time, and maybe there are records we don't have, but from what I've seen, there was no supporting documents. So that, we've got to move on. I mean, you wanna get in more stuff? I mean, we can talk about this all night, but I don't think we're gonna come to a conclusion on it.
Well, again, what's interesting is if you look at Teresa Walter, one of the commissioners who was on the board at the time when the 2015 decision was issued. Because again, a non-conforming issue was investigated by a complaint in 2015. Now, Teresa Walter responded to Mr. Locker stating, "I remember the situation and it was confirmed as a legal non-conforming mine at the time." Is she wrong?
I don't know. We're gonna move on.
One thing I think that, I know some like to use analogies, so I'm gonna use one. You get approved to build a house, and you live in that house for over 10 years. No problem. You pay your taxes when they ask you to pay. If they increase it, you pay it. You give anything that they ask, you submit, you provide your records, whatever you have. And 10 years later, because a new zoning administrator comes in who sees things a little differently, says, none of those decisions matter, and closes you down. And here's the problem I have with that. In the next section, there's two other complaints that were raised against non-conforming mines. One against Harlan Nelson, and one against Burning Rock Products for their Skyline quarry. Both of those individuals were allowed to go through the CUP process. But when it was brought up about whether we could, on October 17, 2017, Mr. Locker stated at the board meeting that they already have two CUPs and we don't have the time to go through another one. But that if we have to go and get a CUP now, the cumulative effects take account, and we have to do all these extra studies. And what's interesting thing is what he told Mr. Nelson.
What do you mean by cumulative effects?
The fact that there's another quarry to the south, you have to take that into account and whether your quarry can continue.
I get it.
And this is what he says to Mr. Nelson. That his quarry, a non-conforming, could continue as it was being operated previously, but the county would not say whether it's legal non-conforming, but encourage him to get a CUP. So for Mr. Nelson and Mr. Bruning, they get to continue operating and go through the CUP process. But Mr. Locker just shut it down. No working with us. Didn't want any of our records. Didn't want to talk with us. And on his PowerPoint, there was no mention of working with us to get a CUP. It was stop work order and close with send a letter to close it and reclaim.
Did you request a CUP?
Well, we weren't even given the opportunity to get one.
I guess I don't know. I would think you would say, yeah, I'd like to get a CUP. You've been in this business a while. You know what a conditional use permit is and when you get it and how you get it.
I also know what non-conforming mines are too, and they're also protected property rights. So again, I understand you don't want to hear any of the rest of this. I'm going to submit all these emails that show that there was involvement in this decision by commissioners, certain commissioners who were emailing, checking in on this. There were numerous instances where the complainants were getting updates, emails where they were threatening war on zoning, all of these things that show that there was likely bias, predetermination, the fact that Mr. Locker hadn't made a determination, yet didn't tell anybody during the Bruning pit that there may be another quarry there, which means he made his determination well before he got any of the facts or finished his investigation. His investigation, I'm sorry, it relies on false evidence. That decision relies on false evidence. How is that fair or reasonable?
I think that's part of our determination to determine, whether or not we believe some of this evidence, right? I mean, that's what we're here for.
Well, that's pretty much for the courts too. We need to determine if our zoning administrator did followed our ordinance in his determination.
Excuse me. It needs to be determined if he has substantially, or he has provided by a preponderance of the evidence, a period of discontinuance for a period of 12 months.
Can we ask questions at this point?
Certainly can.
What I would be interested in is if you have any actual evidence that would show that there was activity in that mine prior to 2006.
You're talking about getting records that are decades old. That's part of the,
Any evidence at all?
that's part of the problem when you go back and make it and reverse a decision 10 years later. I mean, people only retain records for so long. I mean, we know he didn't even go, the county doesn't retain
The
records.
answer is no, though.
No, they don't exist. All I've been able to do is present to you that the facts that he relied on, or the evidence that he relies on, is false, inaccurate, misleading, or unreliable, which means the entire decision, even if you agree with certain parts of it, it's tainted. He relied on false evidence. Are you okay supporting the decision?
Well,
relying
that's
on
our
false
determination,
evidence?
whether or not
I
it
know,
was
I'm
false.
asking.
We haven't determined it's false.
But I'm asking, do you, well,
How would you well, we can go back and forth. We're not gonna,
We need to have comments from other people, perhaps.
yeah. Oh, where's my cheat sheet here? Do you have more information for us?
I do, but you won't let me present it, so I submit it for the record if and when we need to appeal.
All right, good, thank you. Do we have comments from other people in the benches out there?
Yeah,
Mr. Myers?
Please stand, state your, come up to the microphone. State your name.
It's Gary Miners. I guess Mike brought up a lot of good points, and one of the points he made is I probably shouldn't answer a lot of questions because of potential litigation and stuff. Okay.
Thanks.
I guess all I want to have you guys think about, and Mike is a lot sharper on this stuff than I am. I'm just going on a common sense, let's talk. I made a business decision based on a letter coming from this county. I made a long-term business decision. I would have never made that if the county wouldn't have encouraged me okayed it. I guess I want to know what can I trust of the county? Because I made a long-term commitment, and now all of a sudden the county said, our letter is no good. How do I proceed? The ramifications of this thing is unbelievable. I've lost part of a farm over this already because of my lender pulled my funding because of litigation that's going to happen out of this. Is the county liable for it? Who's liable? I mean, I'm out, and I just go back to the fact I base my business decision on what I got from the zoning. The other thing Aaron keeps saying is his staff, and making it sound like they're all in agreement. They're not. His staff is not completely in agreement with what he's doing. The other thing is that presentation that you watched, I watched it at a board meeting. You do have a commissioner here right now. Aaron presented that. I remember distinctly him saying, the reason I'm bringing this up is I want your backing. I want your support on it. There was never a vote for the support. One man can put me out of business. I don't think Houston County needs that. I think you guys, if you were in my shoes, you wouldn't be very happy either. And I go back to what Mike said, what good are the building permits in Houston County if the zoning commissioner can overrule it? Why, I talked to another quarry operator. who's not in Minnesota, he said he would never come to Houston County with the zoning we have in this county. That's pretty sad, because we're, down the road, we're gonna pay for this. And the other thing, the one point I kind of have to laugh to myself is the consistency of the zoning is unbelievable. I keep hearing about 1 year for abandonment. Right next to my quarry, Bruning got a new quarry going through. If I read it right, they have in there, one of the amendments, 5 years. If they're not operated for 5 years, it's abandoned. Why is 1 year, next time it's 5? I don't understand.
I don't have an answer to that.
I don't think anybody does.
Do you want me to tell you why that is?
Yes.
If you're willing, if you want to, yeah.
The Bruning CUP has a condition on it. Non-conforming mines are not CUPs. It's the same reason why the analogy about the house is errant, in that if you build a house, it's permitted, and the new zoning administrator can't revisit a prior issued permit. But a non-conforming determination is the opinion of the official charged with making that decision, the zoning administrator. It's not a permit.
It's my understanding if that condition wasn't on there, it could be inactive for 50 years and still
Correct,
maintain
if
its.
it didn't
right,
have a condition
because
that-
of the CUP.
Yes.
I guess it goes back to common sense, though, you know, I mean, I got this letter, you guys seeing it, Kruko's got it and stuff. I based the business decision on it. Why do I have to suffer because we got a new zoning administrator? Everything was fine, and it's not 100% backed out of that zoning office, I guarantee you that. So you guys gotta look at common sense part of this too. And Mike presented a lot of good things, and I think you gotta consider them. And how Houston County come to the point where one person can shut a business down. There was no board that ever okayed this decision. The county board never did, and there's no other board that did. And the county board did not give him his support that he looked for.
Well, like I said, that's why you get a conditional use permit. You have a public meeting, you have a formal process you go through, and that can't be overturned.
I am
That's,
not,
I know, I agree with you 100%. I didn't know that, but that's the
I'm
same
a
reason.
landowner, I don't know all that stuff,
I
and
agree
I'm
with
not
you.
gonna get involved in that, but, you know, I'll guarantee you, any one of you guys sitting up there would have the same feelings I do right now.
I'm sure I would. I
You know,
would be 100%. But that's also, well, I better get,
If I may, the ordinance talks about that if there's a issue of non-compliance, that there's a process to follow to determine what to do with that permit, right, in the ordinance. It talks about the zoning administrator sends a letter of non-compliance to the board. The board then will hold a notice in the hearing,
I'm
and they
not-
get to decide. Now, a non-conforming right is still a property right. You may not like it as much as a CUP, but it's still a property right, a protected property right, and you cannot revoke it without notice in the hearing. Where was that before it happened?
I
Isn't
don't,
that
I,
what this is? This is
No,
due
that's not what
process.
this is.
Wait
It
a
was
minute.
revoked before.
Larry, for the sake of expediency, I think we ought to have public comment from the public, and that the applicant's
Yeah.
testimony has ended. We don't need a commentary on each person who speaks. Perhaps he ought to.
yes,
leave the
you'll have an
bench.
opportunity after you get public speaks.
Well, I don't know what else to tell you, I just, you know, if the county's gonna operate this way, we got a lot of problems.
You keep saying the county's gonna operate this way.
The zoning-
I've thought of it several times, and when I do decisions with property, I get an attorney to look at it. You know, that's just the way I do it, and you probably wish you would've. I mean, that's just, there are some things that you have an attorney look
did
at.
look at that letter from the county. The attorney did look at it,
Did
that's
he?
the reason we got that letter, so I could proceed with that.
I'd go back and talk to that attorney.
Huh?
I'd go back and talk to that attorney. I mean,
What can he
that
do?
letter is not a conditional use permit.
No, it's,
That don't make sense. If you get a letter and it states something in there, and 10, 15 years later, they change their mind, that just don't make sense. It just don't. I mean,
I don't know, do you have any other
boy,
comments?
you know, if that's the case, I'd like to buy land from you. You know, I mean, I'd change that 10 years from now. You know, you wouldn't have been happy either.
My attorney would though.
Yeah, well, then we'd be in litigation, huh?
Mr. Miners,
Yes.
before you leave, I'd like to ask you a question. On this letter that you sent to the county, it says, was the quarry active when you took ownership of the parcel? Did you put no on there?
Whatever I wrote on there is what I put on there, but I am not gonna get too involved in it, but I didn't understand exactly what they were
Okay.
asking.
And,
So, I
You
don't
said
wanna,
that- Has the quarry been continually active during the time?
I told you, I'm
owned
not
parcel?
gonna answer any more questions like that, because I don't want, I try to be upfront as I can, you know?
Okay.
And Aaron's letter even states that he appreciated the fact that I was there upfront, and, I'm being upfront with you right now. So, you know, I know that I don't wanna get into anything where litigation's
You
gonna be
realize
involved.
that letter sent by him was his attempt to determine, one of the things he used to make his decisions, them letters.
We had discussions, and
But
his
he did that-
discussions were one-sided. Yeah, you need.
And that's
to
what
be
we're
there.
trying to determine.
Yeah, you know, I mean, and some of them letters that he said that were sent out to all rock quarry owners, I never got that, you know, but it would have been when the Schutzes had the quarry. So I don't know what happened, but I never received what he was talking about,
Who he?
What do you mean?
Aaron, on
What
his
didn't you receive?
presentation.
What didn't you receive?
He was talking about some letter way back, and,
He wasn't there way back. That was their previous zoning administrator that sent them out.
yeah, and I never seen that, so.
Is there anybody, I'm sorry, do you have any more?
Any more?
Is anybody else interested in comments?
Thank you.
Please come forward and state your name.
My name is Yvonne Krogstad, and some of you are probably aware I follow the county politics quite closely. And it appears to me that every courtesy was extended to the Skyline Materials when they were going through a process, and the opposite was apparent for the Krukos. And I believe that's wrong. Everyone should be treated equally, not show favoritism, especially when Skyline is not only not paying taxes in Houston County, they aren't paying taxes in Minnesota because they are from Iowa. Krukos are from Houston County. So let's be fair to everyone. Don't show the favoritism. Thank you.
Thank you. Anybody else interested in a comment?
Audrey Elmo from Minneapolis and Caledonia. I just want to say that because I own the cabin right downstream from the quarries, both of them, and in the last 10 years I've been flooded maybe 4 or 5 times. I've lost my well pumps, my sauna floor, the basement steps are all rotted away from being covered with water. And the only concern I have about another mine opening up is that the slant is, well, even with the Winnebago quarry expanding across the street, the land slopes down towards the dry run, and I have a concern about more water coming into my cabin. And it took, over a year to get somebody to say that the quarry was responsible for the flooding, and I told them that the dry run would get full of gravel and stuff, and the water got diverted to a backfield, and then it would come on my property. I mean, we had the cabin for 35 years before and we've had floods when Camp Winnebago got demolished, but the water always stayed in the dry run. So now, I could be sued because the handyman he was cleaning out my sauna again and the floor just gave way. And now he went to the basement to get the old pump out and the step let go. So, and I'm afraid to go down there. But something has to be done about the water control down there. And seeing Camp Winnebago is now a new venue, I think there's going to be a lot more traffic down there. And I haven't been able to use my cabin for 2 years now because of water and problems. So,
All right.
take that into consideration. Thank you.
Thank you for your information. Anybody else? Anybody else? I don't know, is it necessary? I don't know that anybody,
I don't think there's anything to respond to in those that would make it necessary to extend the meeting. But that would be your decision.
yes. Anybody have a problem with that? Consensus? Okay, here's public testimony. I'd entertain a motion to conclude the public hearing and reconvene the Board of Adjustment.
So move.
I'll second.
Motion's been made and seconded to conclude the public meeting and reconvene the Board of Adjustment. All in favor say aye.
Aye.
Opposed, same sign. All right, so we're back to the the Board of Adjustment. Where are we at? The board is charged with reviewing the administrative decision made by the zoning administrator.
Well, first you need to, I guess, discussion is where we'd be at, so.
Oh, do we have any discussion amongst the board members?
I'm just gonna go back to the aerial photos that you relied on, that you did the measurements on. Tell me that process again.
The original 44, 45, and then the 68 photo are from older film photographs that show the quarry.
And who took those photos?
I
Oh,
have
okay.
no idea.
Okay. Beacon, okay, well.
Probably not Beacon, no,
No,
these are from
probably not.
1968, so
Right.
they're taken from an airplane.
Lindbergh.
Yeah, right.
The county retains them, and there's some notes on some of them. Worked with the county surveyor to determine the distances to make an approximation of the size. And I guess I wasn't very fixated on, calculating it to the square foot or the cubic foot. I didn't feel that was necessary. They're all approximations to show size. I thought it was sufficient to, if you could show that it approximately increased by, say, 25% of an acre or 35% of an acre. I didn't see that as vastly different outcomes. The other photos are from Google Earth. They show historic photos back to 1991, and then at intervals up till present. The intervals are just, I believe, whatever photos are available.
And there's nothing between,
There's nothing that I could find between 91 and 68.
okay.
What is your level of confidence, Aaron, in those two measurements being the same or very close to the same?
Well, I guess I wouldn't say that my level of confidence in whatever area I stated is probably low because it's an approximation. I'm fairly confident that they were approximately the same size. Whether it's what I said, 0.32 or 0.2, I wouldn't be very confident in that because we are using old photos that don't have the they're not high definition photos, but I think they're sufficient to show what needs to be determined for the decision I made.
Did they have a scale on them?
Well, the Google Earth photos,
Oh.
they don't necessarily need a scale because you can
Yeah,
draw.
but the old photos, did they have a scale?
Well, I didn't even bother to look for the one in the 40s because it wasn't necessary. The one in the 60s, yes, it has a scale.
So when you saw the, I'm sorry, Larry.
No, go ahead.
Okay, when you saw the diagrams of of the quarries and the differences in the angles and things like that. Are you confident that the picture that you have?
Again, I can't be 100% sure. You know, basing it on pictures, especially if someone who's presenting the pictures has a, you know, an incentive to reach a certain outcome, I guess generally, not specific to this, but I might be suspicious of that. If you're taking pictures and then claiming angles, definitively prove your point. But I'm not 100% certain that he's incorrect. That photo, if indeed there are two quarries that have the same state ID, it is possible that that photo is of the other quarry and not the one in question. However, I think with all the other overwhelming evidence, it wouldn't be necessary to rely on the photo alone to reach the conclusion that I reached.
I think I want to suggest something here, and I am very empathetic to your situation, Mr. Miners. And I myself have been put at risk and had to pay some serious money because of past zoning problems in this county. And I think Mr. Krukow stated previously that in another case that you've felt like it was impossible to make good decisions based on our past practices of zoning in this county. The Planning Commission chair said the ordinance has not been enforced in 40 years. And so, but the issue is, do we continue to let things ride in this haphazard way that continues to throw people under the bus, or do we come clean at some point and make decisions that hopefully work towards a more transparent and consistent process that allows people to make good decisions? And while in some cases I agreed with your input, Mr. Krukow, that some of those pieces of evidence are probably flawed. But at the same time, I can look at a photo and roughly tell if it's overgrown with trees or not. And there's a 40-year period here with apparent inactivity based on everything we know. And even if it was a few-year period, it would be adequate to lose its non-conforming status. And we have to go with the preponderance of evidence, and that seems pretty clear to me. I do hope that we can, I feel like Aaron's trying to clean up some past mistakes, and I think some people are going to get hurt in the process, and that's very unfortunate because injustices bother me as much as they bother anybody, and I've been the victim of them, so I understand. But we have to start enforcing the ordinance in this county, I think. That's my speech.
My biggest concern is basically Mr. Krukow stated that it's a quarry that basically takes shot rock out. No crusher operates in there. Am I right on that? There's not room for that. So we have really, an aerial photo won't show how much shot rock is laying in that quarry. It just basically has the footprint. He stated also that this last shot that they did this recently could last up to 20 years. Without any concrete evidence that there was no activity, I think we have to look only possibly after the time Gary Miners owned the property, except that the previous administrator evidence was correct at that time.
I guess I don't accept that at all. this quarry has changed hands, the ownership has changed hands, the lease or leasee has changed hands, and during all of these different changes, there's no evidence of continuous use. And if it was inactive for a period of time and changed hands, that certainly would constitute abandonment. And there's no evidence to the contrary.
There is crushed rock in the quarry currently too, so I guess there's processed gravel stockpiled in there today, as far as I know. Last time I
Yep.
was by there.
Change of ownership does not change the status, if I remember
No,
looking at
that's
the
correct.
statute.
But my point is that you don't have any continuous record of anything that anybody can track back on or ask anybody about or anything.
In terms of the burden of proof, I know that you were told that it's for us to prove that it was not operating. I don't subscribe to that. You could ask the county attorney. In my investigation, it's on the preponderance of the evidence. There's no great case law on this. But if we provide evidence that it was not operating, that has to be rebutted. And if it's not rebutted, it's not up to us to prove beyond a reasonable doubt that it was not operating. It is the preponderance of the evidence. Is
Is
there
that-
more to suggest that it was, or is there more to suggest that it was not?
Is that correct, Mr. Yant? I couldn't hear you.
That's accurate.
So what there was, from 68 to 91 is the unknown. Is that right?
Well, till all the way to 2005 or 6.
Well, there was 91, there was, I think there was a shot from there, or some shot rock hauled from the county, took shot rock out there.
But that's not our issue. I mean, you know, whether there was additional activity after 91, really. we're
Yeah,
not here
I don't
to
think
determine.
anybody could, I don't think there's any
There's no,
disagreement on that.
that's not in dispute, let's put
No.
it that way. We're
So
not
we got
dis-
68 to 91.
Right.
I didn't see anything that indicated, other than what he just said, and I don't recall hearing that, the shot rock by the county in 91.
Well, I thought that's what maybe I'm wrong on that.
No, in the 1990s, they
Oh, that was
We hauled
Photoshop.
shot rock out of there in the
Right.
early 90s.
Okay,
Because
you-
the Schitzes were longtime customers of ours.
Okay, I missed,
Now, we were never the exclusive leaseholder on that day.
see, you hauled rock out of there in the early 90s. Okay.
Yes.
And I guess another thing about the shot rock comment you made, the operation now with the crushed rock in there is attempting to operate not a site that just hauls shot rock on it,
Right,
but
okay.
processing the processed rock in the site, so there's a difference.
But still, it's the 68 to 91 piece.
Right, that's the issue.
Unknown.
And probably from the
And,
90s to the-
how do you, what's available to make that determination? How do you do that? I mean, I'm saying that Aaron looked at it and said, I don't have anything but these photographs. They're, at best, they're not good, but, I talked to Mr. Miners and he doesn't, he said, well, I don't know if it was operating or not. I mean, I kind of think if you were having your quarry, you'd be getting money from it if it was operating. I just don't know. I mean, how do we make a determination of that? I mean, that 68 to 91 piece is I don't know that anybody's had any evidence other than what Aaron brought up to indicate anything on that. I mean, we looked at when Kruko was there and what they did, and I don't think anybody disputes that, but we're still stuck with that 68 to 91.
And early 90s to 2005.
Well, it's
That's 10
meaningless if we don't.
We basically have no evidence one way or the other. We can't determine whether it's operating in 68 to 91. We have nothing to determine one way or the other.
Well, we do have the ordinance that says that those kinds of uses are not to be encouraged. So if we have no idea, then we'd have to vote that it's not conforming, that it would lose its non-conforming status.
I don't know what you mean, the ordinance.
Doesn't the ordinance say on non-conforming that any for 1 year, any non-use is called, it is deemed inactive.
Yes,
Just 1 year.
yes.
It's not, with the footprint of that thing from 69 to 91, you can't really say there was something done every year in that.
Pretty tough.
There's gotta be a year when nothing was done, and then they lost their non-conforming.
I mean, when we consulted legal counsel about that, that standard for mines might be a little different. You know,
3 to
Mike-
5 years, I think,
Michael
was
Krugel
what.
talked
For
about
the standard amount.
average times and whatnot, and, you know, we didn't use the average time for the Winnebago, we
I
didn't
was just
average
reading.
any times, because in that conversation, the other follow-up was that if it's been inactive for 10 years, it's a clear-cut case. There's no need to do any sort of, averaging what other mines are doing. 10 years would clearly qualify as abandonment.
And this is what, 30-some years?
Even 10 years is hard to say.
But if I may, again, it hasn't expanded and won't for close to 20 years. This is a small quarry. And just remember that, it's a low-intensity, small quarry.
I think the aerial photos will not show any activity at all. The footprint is too small. And
Well,
no changes in that footprint will be real readily visible if it's a small amount taken out.
I think the value of them is to show any overgrowing,
Yeah,
you know.
but
I mean,
that's hard to
you're
pick
saying-
out too, depending on the time
Yep.
of the year.
Do
Well,
you think you can see changes in it from the lease time forward? You know, the photos from
Yes.
2007 forward? Are you able
Absolutely.
to see?
Yeah, you
Yeah.
That part you
yeah.
can,
Yeah.
but beyond
Yeah.
that, but other than that, no.
And is it the clarity of the photos or the fact that there's no excavation going on? I think that's
And
what you
the
need to
point-
determine when
point
you're looking
is-
at the photos.
When they make the shot, they don't always haul, it's not an expanding shot like the bigger quarries.
well,
Let's vote.
I don't know that we can, I don't know if there's any reason to delay this. The board, if we don't have any more discussion, the board's charged with reviewing the administrative decision made by the zoning administrator. The decision can be affirmed, reversed, partially, or wholly. Findings shall consist of the reason members have for their decision. Can someone provide a reason to affirm or reverse the zoning determination that the Schultz quarry does not meet the criteria necessary to establish and preserve non-conforming use status?
I do have one more question, Aaron. Will the Schutz Quarry get fair consideration for a CUP just like any other quarry?
Yeah, the reason why the other quarries are perceived as being treated differently is that immediately when the issue of permits arise, the owners of those sites indicate their desire to obtain a permit and begin the permitting process, where in this case, the owner of this site indicated his lack of any interest in getting a CUP. So if the applicant is not going to move to correct the problem through a permitting action, then we move on to an enforcement action.
If I may, the comment was made on October 17th that the zoning office couldn't handle any more CUPs, and that he believed it was illegal mine.
Yeah, so he's correct, we cannot handle any more CUPs, but we have to deal with the permits that come in. The application for a CUP is available on the county website. Anyone can download that whenever they want, fill it out and turn it in, and we have to process it.
What do you mean you can't handle any more CUP?
Well, I guess that was a comment perhaps being presented out of context that had to do with the workload in my office, and that we were so busy, we can't handle any more mining CUPs. But we can't prevent people from applying.
He's letting others still operate as a legal non-conforming mine, even though they said, oh, I'll apply for a CUP down the road, even though they haven't.
Yeah, we did extend that courtesy of the Winnebago quarry. It now has a CUP. We're working through these quarries to the capacities of our staff, and we cannot look at 50-plus sites in a 12-month period.
And again, we didn't get that same courtesy.
But Well, again, they did, and that the owner of this site, not the operator, but the owner would need to apply for the CUP and indicated no desire to do so. In fact,
I personally didn't know what you were talking about there, and I am saying, financially, you're killing me now. Why am I gonna spend more money doing it? You know, I mean, that was very unclear what he just said to me.
I tried to present it in the way I guess I
Yeah.
could, the most clear, and I have to.
But it has to be by the owner.
Yeah, the property owner would have to sign a permit application. We wouldn't give a permit to property that someone doesn't own.
Okay.
How much does it cost to get a CUP?
The application fee is $500.
I want to clarify though, on October 17, 2017, Mr. Locker also stated that if we decide now to go get a CUP, cumulative effects are going to take account, and it may be more difficult for us to actually get one.
That is something that can impact our decision, though. We're deciding on the non-conforming terms of continuous use or not.
Which you have no evidence to support a 12-month period.
We'll decide that.
So, what are our options here?
You can reverse my decision, you can affirm my decision, wholly or partially.
Wholly or
You can say
partially?
some parts of it were correct and
Or
other
can
parts
we
were
add
incorrect.
conditions to it, or?
I guess I'm challenged to think of what one might be, but if there's a nexus between the condition you want to add and the request, yes, you could.
What about a time frame for a CUP?
I don't think you could, you mean
That's not
allow
planning-
operation
planning.
provided they apply within a certain amount of time?
Right.
I think we just need to decide to affirm or disagree. with
Because you
think
don't
we
know
can.
that the CUP will be applied
Yeah,
for
we can't-
and/or approved.
We can't,
Well, then
That's not the
sure.
decision I made. I guess I said that it doesn't qualify as a
I
non-conforming
got you.
mine, and you're deciding whether that was correct
that's
or
what we're
not.
deciding.
Okay, okay.
So maybe give them the directions, because we don't have specified findings that we're answering to. You're gonna have to create your own findings in this, in an appeal instance.
Yeah, that's what I did. I thought when I read this, the board charged with reviewing the administrative decision made by the zoning administrator. The decision can be affirmed, reversed, partially or wholly. Findings shall consist of the reasons. The findings shall consist of the reasons members have for their decision. Can anyone provide a reason to affirm, reverse the zoning administrator's the determination that the Schultz quarry does not meet the criteria necessary to establish and preserve a non-conforming use status? I'm looking for a motion.
I'll make a motion to vote to affirm Mr. Locker's decision.
Well, first we need some reasons as to why you would do that, because we need some findings.
Well, I said some of them previously, but I think the predominant issue is no evidence supporting continuous use from 1967, I think it was, to the mid-2000s, with the exception of hauling, one person testifying to the fact that some shot rock was hauled out of there in the early 90s.
So lack of evidence that it was, do you feel that there's any evidence that it was not?
Yes, I think the aerial photographs, while you can pick at them, there is clear evidence that they're overgrown with brush and trees for a number of years there, and I think there's at least significant evidence that there was inactivity there for an extended period of time.
Okay, what we're gonna do then is I'm gonna try to condense that into 2 sentences, and then we're gonna go on a roll call vote on that as a finding. Then we'll have an opportunity if somebody else wants to present a different finding, or another finding, or an opposite finding.
Somebody's got to second it though, right? I mean,
Yep,
otherwise it's
after you-
nothing.
after he does that.
Where are we now? We're looking for a second? No.
No, he's gonna restate it.
Okay, gotcha. I got lost. Sorry.
So, is this an accurate summary of what you said? There's no evidence supporting continuous use from the 1960s to the 1990s. Photographs clearly show brush growth prior to 2006.
I would say all the way up to the mid-2000s, with the exception of one statement of hauling some shot rock in the early 90s. So you have 40 years there with one small period of activity, apparently.
So, we would, do you want to second this as a potential finding, or do we just want to vote on this one and see if people, because if it's, if not 3 people support this, it will not be a finding. If 3 people support it, we can move on, we can begin to get other findings. The future findings don't have to necessarily be compatible with this. We'll vote on those as well.
Don't you need a second on the
I
emotion?
was gonna say, we should go ahead and vote on this. Do we have a second?
It's just a finding,
I'll
so maybe
second.
we don't. Okay.
Dana seconded it.
Wish we knew the
Just a
process.
minute.
Okay, so that statement. The question is, yes, you agree with that statement, or no, you do not? Again, the statement is there's no evidence supporting continuous use from 1960s to 1990s. Photographs clearly show brush grown in prior to mid-2000s, with the exception of one load of shot rock being
No, not
hauled.
one load, one period.
One
I don't
period.
remember exactly how Mr. Krukow stated, but he said there was some mining for some, in the early 90s of shot rock.
Do you want to attribute that shot rock being hauled out to the photographs? Because it kind of reads that way right now. Or do you want to attribute
I
it to?
don't know that. I can't say that.
Well, I'll leave it as is then.
So we have a motion that's been made and seconded. You want to read it one more time?
No evidence supporting continuous use from 1960s to 1990s. Photographs clearly show brush grown in prior to the mid-2000s, with the exception of one period of shot rock being hauled. Are we comfortable with how that reads?
Do we want a individual vote?
We do.
Let's see, let's start with Ken Anderson.
No, I disagree with that. I don't believe the photos show one way or the other.
Larry Hefner, yes. Dana?
Yes.
Brian?
Yes.
Ken?
Yes.
Motion been made and seconded.
Okay, so
Three
same
yes.
process. Is there another reason that
It
somebody has
passed.
for the way they would, for the way they might decide this, that we might use as a finding, one way or the other?
Yes. I think that form that the owners signed and where he wrote on there, no, it wasn't active and hadn't been active for quite some time. I know, he said he didn't understand it, but that's the documentation we gotta go with. That was the basis of Aaron's decision made by that, and that was what Aaron had to go by.
It doesn't say though for quite some time though. It just
No.
says it wasn't continually active.
I think it said 2 years or more or something.
It doesn't.
I gotta look for that
It doesn't, it just asks.
anyway.
Just asked if it was active when he
And that's
acquired
what-
it, and then
and
it asked if it
that's
was
what-
continuously
He
operated.
sent it to
since-
you and you made your decision off that and he said he was, I have empathy for Mr. Miners, but that's the evidence Aaron had to go on. That's what we're voting on,
Yeah.
not what that's all I got to say. That's,
So I have that, and if I'm trying to kind of paraphrase what you
yeah,
said there.
you can do it better than I can
The
talk.
form that the owner signed saying site was not active upon purchase and not continuously active thereafter.
Yes.
I will say you guys are reading into more what I said there than what you should be. There's a lot of questions there.
So with that in mind,
Do we have a second to that motion?
Second.
Motion been made and seconded to,
So we'll do a roll call vote on that as well.
all right. Start with Ken.
Yes. Which Ken?
I'm sorry, Ken Visser. Sorry.
Ken.
Start with Brian,
Yes.
Dana,
Yes.
Larry, yes. Ken Anderson,
Yeah, I guess I agree.
5 yeses, motion passed. Are there any more findings?
Any other evidence that you're relying on to reach whatever conclusion you're reaching? Or information, anything said tonight?
I think that the information that was provided was a good presentation, and it basically put some of the things in the report at question, but it didn't, for me, it was still an either-or kind of a thing. It wasn't clear who was right and who was wrong when it came to photographs and MnDOT and all those kinds of things, and the slopes, and so I'm having trouble with some of those findings, but I'm not prepared to dismiss them.
I would maybe just add, Aaron, that the preponderance of the evidence appears to indicate.
Hold on, do we want to, are we making a finding? Is that something we want to?
I don't, I'm rambling. I don't
Okay.
think I'm saying anything worthwhile. It's just in my head.
I think you're saying something very, very bad.
So Brian, go ahead, I'm sorry for interrupting.
I think the third finding is just that the preponderance of the evidence would lead one to believe there was extended periods of inactivity between 67 and mid-2000s.
I don't know that you really have evidence of any activity, you just don't have evidence of activity.
Correct. You can't have evidence of something that didn't happen.
Yeah, really.
That's impossible.
But you don't have any verification that in that period, especially from the 67 to 91, that there was not some activity taking place. We don't have any records of that time.
No.
So we have nothing to go by on that period. To my notion, the only area we can determine the inactivity is from time that the records are there,
That's 91,
from 91.
right?
I think we should ignore that part period earlier and just worry about that period.
Let's finish yours, and if it doesn't get a support from
Preponderance.
somebody else, we
Who
won't
did
do
a
it.
second? Do we have a
It
second?
was
Go ahead, read it out.
preponderance of the evidence would lead one to believe there were extended periods of inactivity from what are the dates?
1967 to the mid-2000s.
I think it's, yeah.
Okay. So is there a second person who would subscribe to that interpretation?
I'll second it.
Okay, so then we're going to do a roll call vote on it. Ken Visker,
Yes.
Ryan Van Gordon,
Yes.
Dana,
Yes.
Larry,
Yes.
Ken Anderson.
No.
Further reasons for your view of the situation based on information we have available to us?
I guess I look at the zoning administrator's recommendation from 2008. And what I read in there, he was in consultation with the highway engineer and the county attorney before he made that recommendation. And that listed that quarry as an operating quarry.
So that would be that the prior zoning administrator was in consultation with the county
Yeah.
engineer and the county attorney?
That's what was stated on the forms
Yeah.
that were signed by the previous administrator.
County attorney was involved?
The county attorney at that time was also listed. Not by, I don't know by name, but
Thought it was the zoning administrator. That's right.
That doesn't support the motion on the floor, is that what we're doing now?
that's my, I'm
Well,
just
it
stating
doesn't support
my
it, this is
basis
a
of it.
finding.
Stating why he voted against.
Do we have,
Do you want to attribute that to both decisions or just one? I can't
The
remember.
decision in '08 was based, if I remember right,
She did. Oh, wait, okay. Okay, is there a second person who subscribes to that?
you wanna, we're gonna restate it?
Sorry. The finding would be that the prior zoning administrator consulted with the highway engineer and the county attorney prior to the 2008 decision.
I'm looking at this and it doesn't say the county attorney, it says the zoning administrator.
I think one of them had the,
What is that
Read
motion?
it, Ken.
It's on two occasions, the zoning administrator, I'm sorry, not the zoning administrator, the
Environmental
Rick
Services
Frank,
Director.
Environmental Services. I then had discussions with Environmental Services Director Rick Frank, and then it goes on to say that I held an on-site meeting with Gary Krukow, Mike, Environmental Services Director, and County Engineer Brian. I don't see any reference to the county attorney unless you can correct me.
This is Mr. Scanlon's affidavit.
That's
what I was
Is that the one?
referring to.
That's what I'm looking at. Oh,
It's in his affidavit.
that's what I'm looking at.
I was sure I'd seen it also there, but.
Does that change your, I mean, if it's the environmental
Yeah,
services
that's what
director
I'm
or the highway
looking at.
engineer, is that
Yeah.
Well,
really
but it
change?
says he consulted with the environmental engineer, he didn't say it was endorsed by him.
No, he met with the zoning, with
Yeah.
Rick Frank and, well, maybe there is, I don't know. I don't wanna nitpick this, but.
Okay, on point 28, it does say, I had further
Oh, yeah, you're
discussion
right.
with Rick
Never
Frank,
mind.
Brian
I
Potazinski,
take it
and the
back.
county attorney,
Page 2.
Sam Yacht, regarding
sorry,
the
sorry.
non-conforming status.
Okay, so we've got
But he
essentially a motion
It's on
for
page
this as a
Gotcha.
proposed finding. Is there a second person who would support
What
this
was-
as a reason you are deciding the way
Can
you're
you read
saying?
that, what his motion is again?
That the prior zoning administrator consulted with the highway engineer and county attorney prior to the 2008 decision.
What does that mean?
Yeah.
what?
Well, basically,
So
I'm.
what? They didn't say they endorsed it.
His endorsement at that time was that where he was.
But they
Say
didn't
that
say it
in the
endorsed it.
motion.
He consulted with him.
He consulted with them and prior to making his decision to conclude that the quarry was.
So it should be.
But he consulted with him, they did not endorse it. He
The
didn't-
affidavit does not say he endorsed it.
Yeah.
No, there's nothing there.
What's the point? What's the point of your
Well,
motion?
is there a second for it? Because if not, we don't have to debate it.
Do I hear a second? Do I hear a second? Do I hear a second? Hearing none. Motion died.
All right, any other information that you would like to cite as the reason for why you were deciding this the way you are deciding?
Are we ready to, well, let's see, how do we do this?
At this point, I think we want to, a motion to approve these findings as written. I can reread any of them, but the sum of all these findings as written as your findings.
all of them have more than, three or more yeses,
Correct.
so they have majority. Do we want to, huh?
Which does that mean we've already voted on it?
If we voted on each finding, then we want to,
Just like a nice, clean
All right.
roll call vote on these as the findings.
these are the findings.
So a motion to accept, the findings as presented here, as agreed upon here.
So moved.
So I'll second.
We're going to do a voice vote.
We are.
Larry Hefner, yes. Dina,
Yes.
Brian,
Yes.
Ken Visger,
Yes.
Ken Anderson.
I agree that the votes have been done, but I disagree with some of the findings.
Okay. Okay, we did the findings. Did the adoption of them?
So at this point, I think we're on to,
22?
yes.
I'll entertain a motion to accept, reject, or modify petitioner's request to overturn the decision of the zoning administrator dated February 2nd, 2018, in which it was decided that the Schultz Quarry does not meet the criteria necessary to establish and preserve non-conforming use status. Do I have a motion? Do I have a motion?
I would move,
Should I read that again?
no, I move we reject the petitioner's request. Coward.
Do I have a second?
I'll second it.
You want to do the poll of what?
Sure. Ken Anderson,
No.
Larry Hafner.
Yes. Ooh, wait.
What's,
Oh, no, okay. I
The
just.
motion is to reject the.
Yes, no, I was going back to the beginning. I can vote.
So a yes vote is
Yes.
is affirming the zoning administrator's decision. A no vote is a vote against the zoning administrator's decision.
Yes, that's true.
That's what you understood when you voted?
Yes.
Okay.
No, I was
I
just,
understood that.
Okay, so Larry Hafner,
yes.
Dana Chomi,
yes.
Ryan Van Gorp,
Yes.
and Ken Visker.
Yes.
Okay, we have a motion. The motion carried. The, does not meet the necessary, does not meet the criteria necessary to establish and preserve a non-conforming use. Do we need to?
I think we just need to wrap this up now.
All right. Is there any other old business? Is there any other business to discuss? I'll entertain a motion to adjourn.
So moved.
I'll second it.
Can and can, huh?
Can.
Yeah. We have motion second to adjourn. All in favor say aye.
Aye.
Opposed, same sign.